WPC number 19875 of 2019. The writ application has been dismissed.
Item number 2, WPC 30991 of 2021 and batch of matters.
These matters are taken up along with the other matters, but here we found prayers are different, and this is after promulgation of rules 2021. So separate judgment has been passed, and this restriction stands dismissed.
I may be pardon my lord, this bench, your lordship allowed my CMPL, that's the restoration application. Your lordship in the last date allowed my CMPL, that means restoration application. But in the order by inadvertently the number of the WA has been written as 2004, but it should be 2003. Only that modification. The next bench, my lord.
Next bench.
This next.
Please wait, make a mention after we.
No, this bench.
This bench, my lord, this bench. This bench.
All right, that will be listed. Soon.
Fine.
So I've been intimated that may listed tomorrow. So my lord, I have tomorrow, my lord, I have some personal difficulty tomorrow yesterday. So I'm requesting, my lord, I have already filed the counter. Today I saw the copy to the Petitioner Council. Let it be next week, your lord.
It was required to be listed today.
Sorry, my lord.
Those matters were required to be listed today.
Yes. It was directed to be listed.
If you file counter, they will take time tomorrow.
No, I have already filed. I'll stop the copy today.
So they will
We
take
will
time.
see what happens tomorrow.
So, Lord, I have some personal difficulty tomorrow.
Yes,
We will accommodate you, Mr.
Yes.
So may I pray, because the counter has not been served on us, so let my friend serve a copy of the counter and only a week's time to file reply if required.
So that will be
Only
done
week-
tomorrow.
1 week time.
I just.
It's okay. If you're not who wants
Where shall we pass the order?
Very correct. No. I'm sorry. Yes. Your Lordship,
Yes, sir.
let it come tomorrow. Yes.
Yes, Your Lordship.
Okay.
Lord, I may be pardoned to make a mention, my lord.
Yes.
My lord, not in the board. WPC 19033 of 2023, my lord. It's a case of blacklisting, my lord. This matter was heard twice earlier before Honorable Justice Dr. B.R. Selling and Justice Daman, my lord. And thereafter had come before your lordship on 5th August and 6th August. But now it has been delisted, my lord. I pray the candidate taken up, my lord. Why?
Give your slip.
There is a real urgency in the
Blacklisting, the hearing of all blacklisting matters shall be expedited. Please send your slip. Let's see.
Obliged.
Mention the urgency in your slip because that is being taken, taken note of.
So you should mention the urgency in your slip. That should be clear. And all the slips I personally
Quite right.
go through. Please give your slips.
Obliged.
Lord, with Lord's permission, my matter was also to be listed today. My Lord. So, may I request for next week, my Lord, and I'm
2 p.m. That 2 p.m. In fact, 2 p.m. I have changed that. I used to sit
This is
single
not
on
listed
Friday.
at 2 p.m. my Lord. 2 p.m. is other matter.
No,
This was to be listed today, last week. My
It will be listed.
My Lord, subject to my Lord's convenience, if it can be taken next question, Wednesday, my Lord, 17th.
Don't know Wednesday.
I'm giving the details of the other similar matters, my Lord, here.
I may be pardon my lord. Item 36. It has been heard and judgment was issued the tender matter OSMCL tender matter.
All I will say.
My lord.
Pardon to mention, my lord.
You want the judgment to be dictated? So
No, my lord. But
That can be done.
it is common orders for that reason I have mentioned.
so that only.
Orders.
that we can dictate.
It was listed in the top 5 of the list for that reason I have mentioned.
Pardon to mention, my lord. My lord, there was a status quo order. This honorable court directed for implementation of the status quo order. But the authorities, we showed the YouTube proceeding to the authorities. They said, you bring the certified copies. We brought the certified copies, but they are not stopping the construction. And in the meantime, the RDC has vacated the order without any application filed by the state. We have challenged that order as well as the bias of clause B and second proviso of section 3B of the OGLS Act.
The status quo order was passed by which bench?
By the RDC, my lord, and the RDC was not functioning. So we had filed a writ petition
Status quo order was passed by whom?
by the RDC Central Division Cuttack in an OGLS appeal. My lord, the RDC was not functioning, so we filed
Why
a writ.
don't you give your slip? Others have given their slips.
Pardon, my lord, item 13.3, ma'am. WPC number 20830 of 2024. I am permitted to withdraw. I filed a memo.
I may pardon lordship.
Item?
Item number 55 may be taken
13.3.
today.
WPC
We
number
can't assure you.
20830.
Every matter.
33 is
you
not that.
can point out
1330.
113.
that from item number 2 to 54, they are not important. Then it's a different matter. Otherwise,
20830.
we are also trying.
My lord, I may be pardoned. Item number 59 may be taken up today because it is need UG admission matter. Urgent, my lord. Item 59.
Who is appealing for the other side?
My lord,
Appellate is there.
Palit sir or
We'll try.
Next.
One at one piece.
Item number 2.
That's pursuant to lordship direction, the collector is present to the VC. That's I've also got the instruction in the matter. Lordship said, ask the collector to explain why instruction could not be. Lordship will look at the previous order.
Why?
Only question that he has joined recently only 10 days back, Lord. So he was not aware of all these things. Immediately after Lordship's order, I intimated him. So he has reacted stating.
This should not happen in future. Mister, what's your name?
Namaskar, sir. Namaskar, ma'am. Sir, I'm Siddheshwar Bondar, sir. I had joined recently. I sincerely apologize for the delay, sir. But this will not happen again, sir. Instruction.
4/9/2024. Collector Sambalpur has joined online. So, when council and EGA representing the opposite party states that he has received instructions and shall take steps for filing of the counter affidavit by
within 2 weeks. But one thing may point out, Lord, it's not a revenue land. In fact, the land which is allegation made OPSC, Power Hydropower Corporation. So we cannot take any action, Lord, because OPSC has to be made a party. They will make a requisition to the collector.
whatever.
My lord,
I'll file my counter, because I'll file my counter.
Shall file the counter affidavit within 2 weeks.
No.
2 weeks.
Item number 1.
The loss. Reserve the judgment in these cases. My lord, I am giving the submission note. If your lordships want a further argument,
No further arguments. We are going to impose costs. Both the applications have been filed by the same petitioner through the same learned advocate. Please sit.
your lordship. My lord, I am bringing to your lordship's note.
Please sit.
My lord, I apologize, my lord.
Antims, we have heard you so many times.
No, only I point out one thing, my lord.
Have you not pointed out that earlier?
Irritating towards him. Don't, my lord, I am just submitting, my lord. Calmly, your lordship may hear me.
Yes, we are ready to hear you.
My lord, that in single judge matter, my lord, I have given some judgment of the Honorable Apex Court that the single judge matter, your lordships on judicial side cannot hear, advocate that unless and until an administrative order is passed by your lordships being the master of roster, my lord. And if it involves the question of law, then your lordships can withdraw that matter from one or single judge and can advocate as your lordship pleases.
That's all.
Therefore, I have given 3 judgments.
Always, that's all. That's your submission.
Yes, ma'am.
Okay,
Therefore, I
rejecting
wanted
it.
to bring your lordship. Your lordship became irritated towards me, my lord.
All right. Same learned advocate. And since both the matters relate to the same work in question, that is providing for regular service for road sweeping, road side bush cutting, drain cleaning, garbage lifting, spraying disinfectant, where's the name of it? Yep. Relate to same sanitation work from ward number 1 to ward number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, and 20. Of Pattamundai municipality, they have been heard together and are being disposed of by the present common judgment and order. First off, Mr. Mohanty, learned counsel appearing on behalf of the petitioner, has raised an objection over this court taking up both the matters together on the ground that as per the assignment, WPC number second so and so is a single bench matter, and therefore the same should not be heard by the division bench in the absence of any specific administrative order passed by the Chief Justice. Stop. He has relied on certain decisions of this court of the Supreme Court in 1998, volume 1 SCC, page 1. We reject the said submission at the very outset, since we are inclined to, we intend to dismiss both the writ applications for suppression of material facts, which is not only by the petitioner, but on the advice of the counsel for the petitioner. So, stop. We consider it proper to notice the facts asserted in WPC number 24316 of 2023. The petitioner filed the writ application, this writ application seeking a direction seeking washing off letter number 2364 dated 19/7/2023, issued by the executive officer, Pattamundai Municipality, District Kendrapada, whereby the petitioner's contract for providing service was terminated, according to him, without giving him an opportunity of hearing. So, stop. It was the petitioner's case that Pattamundai Municipality had invited tender in the year 2016 from the intending organization to do sanitation work, including street sweeping, drain cleaning, roadside bush cutting, door-to-door waste collection, disinfection in Pattamundai municipal area. So, stop. The petitioner was allotted the work, he having been found to be the lowest bidder. So, stop. Subsequently, in the year 2018, again tender was invited for the same work. So, stop. The petitioner was declared the lowest bidder, and accordingly, the work was awarded to it. So, the petitioner continued the work so allotted. So, on 27/2022, the Pattamundai municipality again invited tender for performing the same sanitation works. According to the petitioner, he had submitted its bid, which was not opened on 4/8/2022. So he has asserted in the writ petition that he was informed after a long time that its bid was rejected during the technical evaluation. Subsequently, it came to the petitioner's knowledge that the said tender process was cancelled by the opposite party number 2. Therefore, he did not challenge the said cancellation of its bid by opposite party number 2. He has also asserted that the petitioner was allowed to do the sanitation work within the Pattamundai municipal area. It is noteworthy at this juncture that the petitioner has not disclosed in his pleadings as to the source from where he learned that the said tender process was cancelled by opposite party number 2, because of which he did not challenge the cancellation of its bid. It is further pleaded by the petitioner that on 19/7/2023, it was intimated that pursuant to the terms and conditions and stipulation of clause 12 of the agreement dated 29/2018, the authority of Pattamundai municipality issued 15 days period termination notice to the petitioner, which was received by the petitioner on 23/7/2023, which the petitioner challenged in the said WPC number 24316 of 2023. Next, the said writ petition was taken up by this court by a single bench of this court on on 2/8/2023. An ex parte interim order was passed by during the pendency of the said writ application, the petitioner filed the other writ application, that is WPC number 31241 of 2023, seeking quashing of the decision of the tender committee dated 28/10/2022, whereby the technical bid of the petitioner was rejected. Stop. In the writ petition, in WPC number 31241 of 2023, there is no whisper about the petitioner having filed the said writ petition, that is WPC number so and so, in which the petitioner had obtained an interim order. Stop. As the second writ petition related to challenge to a tender process, it was placed before a division bench. Stop. The division bench did not have any reason to or basis to know about the petitioner having filed another writ application, that is WPC number 24316. Stop. Only after a counter affidavit was filed on behalf of opposite party number 2, that this court could learn about the fact that the petitioner had filed another writ application wherein the petitioner had obtained an ex parte interim order. Stop. Next. Mr. Mohanty, senior learned counsel, appearing on behalf of the petitioner, has made elaborate arguments to question the decision of the tender committee rejecting his bid document on the ground that the petitioner had not complied the provisions of Employee Preferential Tax. We are, however, not inclined to entertain such submissions in view of the manifest conduct of the petitioner in suppressing material facts. Stop. We are of the considered opinion that the petitioner intentionally suppressed the material fact as regards filing of the earlier writ application, wherein the petitioner had obtained an interim order. The Supreme Court has repeatedly reminded that a litigant approaching court of equity must come with clean hands, and in case any suppression is noticed, the court should dismiss such applications, reject such applications in limine without considering the merits of the case. Reference may be made to the Supreme Court's decision in case of Prestige Lights versus State of Bank of India, reported in 2007, volume 8, FCC 449, wherein the Supreme Court held in no uncertain terms that a prerogative remedy is not a matter of force to stop in exercising extraordinary power, comma, therefore, comma, a writ court will indeed bear in mind the conduct of the party who is invoking such jurisdiction. Stop. If the applicant does not disclose full facts or suppresses relevant materials or is otherwise guilty of misleading the court, comma, the court may dismiss the action without adjudicating the matter. So stop. In case of Satyan, in case of V. Chandrasekharan and another versus administrative officer and other, reported in 2012, volume 12 SCC 133, the Supreme Court, deprecating the conduct of the party, held that the judicial process cannot become an instrument of oppression or abuse, comma, or a means in the process of the court to subvert justice, comma, for the reason that the court exercises jurisdiction, comma, in furtherance of justice. So stop. Paragraphs 44, comma, 45 and 48 of the said decision can be usefully reproduced are being reproduced here and below. So stop. Similar view has been taken by the Supreme Court in case of Bhaskar Lakshman Jadhav and others versus Karamveer Kaka Saheb War, Education Society and others. So, in the Supreme Court, while conclusively opining in that case that since the petitioner had suppressed a material fact from the court, comma, the special leave ought not to be granted. So, the Supreme Court made following observation in paragraph 50. In case of Satyan versus Deputy Commissioner and others, reported in 2020, volume 14 SCC 2110, the same view was reiterated. Same view has been reiterated. So in view of the above, considering the conduct of the party in suppressing material facts from this court in the pleadings, we are of the considered view that both the applications deserve to be dismissed without entering into the merits of the respective cases. First off, what has truly disturbed us that unfortunately both the writ applications were filed by same learned counsel. First off, while filing the second writ application, learned counsel for the petitioner was aware of the averments made in the first writ application. First off, minimum what was expected from learned counsel for the petitioner, that he should have ensured that the facts regarding filing of the first application were incorporated, were mentioned in the second writ petition. Stop. Next, both the writ applications are accordingly dismissed with cost of rupees 50,000 to be paid by the petitioner within 3 months from today, to be deposited in the account of Orissa. Yes.
I am for the upload 3 months.
Into all the models and we have been, see, Mr. We have been very lenient. We must tell you, Mr. Mohanty, we have been very lenient.
I know, my lord.
Yes.
I know, my lord. Cost my boy,
No.
my lord. I pray, and sincerely I pray, my lord.
Sorry.
Only
Sorry.
one impression. my
Sorry,
lord, I
sorry,
clarify.
you, Mr.
I clarify only.
Mr. Mohanty, you questioned the jurisdiction of this division bench to entertain that single bench matter.
Well, that is
based on
on law, my lord.
Yes.
I law. I
Therefore, you may succeed somewhere else.
No, my lord. I bring to your lordship's
Sorry.
notice, my lord, only to your lordship's the position of law, my lord.
Sorry.
I have nothing, my lord. I have not.
Let us, Mr. Mohanty, let us be.
My lord, I
Let us be fair
past
to each
time, my
other.
lord.
Sorry.
My lord, since
No case.
my lord,
In no case.
with my lord, I pray, my lord.
75,000.
Item number 3.
75,000.
Not in each case. Today, I have already solved copy to the Petitioner Council and the Government Council. This is that ultra sororographic matter, my lord. I have filed the counter in the registry, my lord. I have filed the counter. Given copy to the Petitioner Council and the Government Council, I have filed in the registry the counter, my lord. Today. Today, I have filed the counter. I have given copy to them.
I have received the counter, my lord. I have received the counter. I will file the rejoinder.
When?
By Tuesday.
Item number 3.
Yes, my lord.
Item number 3, what have you done?
I have filed the counter on behalf of DMAT and copies up to both the Government Council and the Petitioner Council.
State has also filed a counter on 3rd September. Copy already served.
Yes, this is regarding
That's
Counter, there is almost nothing in that counter.
No, we have just indicated the vacancy position because my lord's direction, we have indicated just vacancy position in different medical colleges.
I have given the detailed counsel. I have given the counter file.
1 week.
Yes.
All a copy of the counter. Copies of the counter affidavits on behalf of the DMET and the state of Odisha have been served upon learned counsel for the petitioner recently. Learned counsel for the petitioner seeks adjournment to file a rejoinder affidavit. List this case on 1 week, 2 weeks. 2 weeks.
1 week's my lord.
1 week. 1 week. Within first 10 cases. Because of the importance of the matter.
Yes.
Item number 4.
May it please this honorable court. Let me recollect, this is a matter where the opposite party had rejected my technical bid without assigning any reasons. Now they have filed their counter affidavit where they've stated that 4 out of the 5 bidders are technically disqualified. It's a single bid and they're going for cancellation of the present auction.
Then
the matter may be disposed
on
of.
behalf of the petitioner has submitted that in view of the stand taken by the opposite parties in the counter affidavit to the effect that all the bidders except one have been found to be non-responsive.
Yes, Your Lordship.
And that the opposite parties intend to cancel.
It has been cancelled in a fresh tender,
And that
fresh
the-
auction.
That the opposite parties have cancelled the
Then tender.
tender and issued fresh tender.
No, Your Lordship, they will issue.
Tender, this writ application has become infructuous. Writ application stands disposed of accordingly.
Deeply obliged.
Obliged, Your Lordship.
Item number 5.
My lord, in this case, I have not received the counter, my lord.
Your Lordship, in the morning we tried to serve him. He said that he will accept it in court,
Only
Your
I have
Lordship.
received one counter.
One, okay, there is 4.
One counter I have received, not more.
I'll keep it.
You tried to serve it on him, he refused.
No, no, no.
In the morning, he said
Now-
he'll take it in court.
Now in the.
Because we
No,
filed it in the
Not
second
morning,
half
my lord.
yesterday.
Now I am sitting in
So
court.
you should not refuse.
No,
You
not
can
my,
tell the court that
not my lord. In here, I have received only one. Then another I will receive in the court for it. I will
no,
receive.
you should not refuse.
Not receive, refuse, my lord. In here, I have not more, or just letter I will.
Lordship, in the last, may I? Lordship, in the last 4 sub items in this item 5,
Change.
except the last one, just above
Item
the
5.
item 5, Your Lordship. Item 6.
Vivekananda.
Mr. Goswami's cases.
Item 5, last 4 sub item, Your Lordship. We have not received the counter as well. An interim order, Your
But,
Lordship.
my lord, out of 7, I have received 4 now.
No, somebody is-
No, also, Your Lordship, in item 17, also similar matter.
Have you filed a common counter or separate counters?
No, separate.
Because facts are.
Yes.
We have not received.
Because my
All the matters.
my lord, all matter is separate cause of action. Because same different IT have a different shortage agreement.
We understand.
Yes.
That
And
we
you
can
lord, the counters are specific, Your Lordship, to the deficiencies that were there and the admission, relating to admission.
All right, so
Yes.
Some,
file affidavits in all the cases.
We have filed, Your Lordship, in item number 5, all the cases we have filed the affidavit. I'll serve a copy.
so some copies have not been
Yes,
served, you
yes.
will serve. When did you file the counter?
All right.
Yesterday, Your
Just-
Lordship, in the
just a
second.
minute, madam.
Yes, sir.
We are adjourning the matter for Tuesday. So
Tuesday.
in the meanwhile, you please ensure
Yes, Your Lordship.
that all the affidavits are filed, served, and
We'll do it today,
Served on
today
record.
itself, Your Lordship. We file the affidavits, we'll serve the copies too.
My lord, item 17, my lord. Similar matter, my lord.
My lord, another item 20, my lord. This cover matter, your lordship, new matter. their interim order not got.
Your Lordship, in those two
Item
matters,
20.
they had not replied to the show cause notice.
Yes, yes, no.
What
this
all you
case,
have filed counter, you tell us, then we will post. to
We
that.
filed in all the counters in and sub-items of item number 5, Your Lordship. All the affidavits have been filed.
There are some more. I think.
17 and 20. Your
17, my lord,
Lordship.
17.
New matters I will.
Item 20, my lord, the press matter, press item, interim order. Your Lordship passed the interim order, my lord, in same covered matter, my lord. Same case, my lord. The press.
Covered means what?
Covered means your Lordship passed in
Covered
previously.
means covered by an interim order or covered by?
Covered by interim order, interim order.
See,
Because other 4 ITs, my lord.
17 is not a new one. It is adjourned to today.
My lord, 17 was an adjourned case, my lord. Last time I was updated on this case.
I'll file
it
affidavit
will
by Tuesday.
17 is-
I'll serve copy. I'll
So
file.
all the matters, all
Yes.
these matters and item number 17 and 20,
Yes, Your Lordship.
all of them will come on
Tuesday.
Tuesday.
Yes, Your Lordship.
And by Tuesday, please ensure that
Yes, Your
the affidavits are served upon them.
Yes, Your Lordship.
And on Tuesday, we will decide what to.
My lord, what happened? Item 20 is a fresh matter, my lord. In other matter, your Lordship passed this order, my lord. So in admission matter, my lord. So that's a admission already extension, my lord. I have filed the memo in the notification of date, my lord. So cut-off date is 30th 9/2024, my lord.
They have extended.
If
the-
your Lordship not allow
They have
this,
extended, you're saying.
yes,
They have
only 2 or 3 ITIs, my lord. Item 20, 22 ITC, that is the Subarna Rekha and also WPC number 22409 and also WPC 22415.
I've received, Your Lordship, I've received instruction from the department. I've received instruction from the department that sub-item of 20, item 20, Your Lordship, they had not replied to a show cause notice, Your Lordship.
And already,
They had not.
Last
my lord.
saying something, please listen, allow us to listen
Oblige, my
also.
lord.
Yes.
All the sub-items of item 5, Your Lordship, on the last occasion, has Your Lordship had held that they had all replied to the show cause notice, Your Lordship. But in item 20, they had not.
Yes, yes. I have told your Lordship, kindly already
Whom are you
spoken.
pointing at?
Please control the movement of your
So, Your
finger.
Lordship, I'll file an affidavit to that effect. But the portals were only open for those who had replied to the show cause.
Mr. Das.
No.
Okay, no, yes, but since he's making an objection, we can do it Tuesday, we can consider it on that day also.
My lord, in this case, my lord, I have already filed the show cause, my lord. Comply report also. But
Might
opposite
have-
party.
Did you file show cause within the time fixed?
Yes, my lord. I have annexed, my lord. So that's why I am telling you.
Please note that if you make incorrect submission, it is subsequently found, you'll, in heavy cost will be.
Analyze, my lord.
All right. This is matters of-
17 we have passed. Mr. Motta.
Along with WPC number.
20 and 17 matter,
No.
interim order,
20.
10 days, my lord. 10
Because,
days the admission, my lord.
Otherwise,
Item
Your
20
Lordship,
and
a second
17,
set of
my lord.
those who have not replied to the show cause, again, they will come
Kindly
in.
peruse, my lord. Because that interim order continue other ITC, my lord. In same status, my lord.
You
They
can
have
let
already
everyone.
complied, my lord.
What is the order?
Item 20, your
What is the order?
kindly peruse.
Just what is the interim order?
Interim order allowed the
Interim order is nothing. There is no interim order.
whatever.
What is the effect of that interim order?
Allowed
You
that.
are allowed to admit, subject to final adjudication. That is
Yes, my
always
lord.
there.
This order, my lord. My lord, I oblige. I oblige your lordship, my lord. This order.
You don't.
This order. Because this order already passed in other ITC, my lord.
All right, we will see it on next time.
Item 20.
No, not now.
Item number 6.
Yes.
No, this matter was listed yesterday, my lord. And your lordship directed that whether we will file counter affidavit by Tuesday. We will file counter affidavit, lordship take up this matter on Tuesday, my lord.
Tuesday, yes.
Small fair as a interim measure, can we remove the materials already stacked there?
No, this is coming on Tuesday. So on Tuesday, since he is filing counter affidavit, and based on your averments in the writ petition and his counter affidavit, some interim order be required to pass, he will pass. Only. So instead of this thing, today is Wednesday you will get the interim order on Tuesday only.
After he files counter, if necessary, again I will file it, rejoinder that.
That is the reason why we don't pass ex parte order generally. Because, all right.
Item number 7.
Yes.
May I please?
What is the delay?
A delay has been condoned.
Not delay.
Caution.
All right, what is the delay?
279.
79 days.
No. The delay has not been condoned.
Have you filed additional affidavit?
That explaining the delay.
You have filed?
Yes. Filed on my 30th April 2024. So file an objection.
Yes. Yes, how much amount will you take?
I have filed an objection to that limitation petition.
15,000. 15,000. No bargaining. 15,000. See, all right. What is the matter about?
A list of 617 candidates was prepared in the year 1991.
Just. Yes.
Sorry, ma'am.
Yes. Sir.
A list of 617 candidates was prepared in the year 1917. 617 was prepared in the year 1991 for appointment as Shiksha Karmi, my lord. Though that list was prepared on the basis of merit, but from that merit list appointment was not given. By pick and choose method, appointment was given. So some of person, those who are in the above in the list, they were not given appointment. Those who are below in the list, they were given appointment. That appointment was challenged before the State Administrative Tribunal. The State Administrative Tribunal was the termination order and directed to give the appointment from the merit list on the basis of merit, not by pick and choose method. Thereafter, that was challenged before this Honorable High Court. And this,
when was the order passed?
Well, that was order. Your Lordship can find page 44, my lord.
Yes.
4.1 that has been quoted in that input order that has been quoted at your Lordship. Para 4.1.
What is the date of the order?
Date of order, my lord. Tribunal.
13th of December 96.
13/12/1996.
13/12.
1996. Lordship, that order has been quoted in page 44, para 4.1.
What point of the writ appeal?
No, my lord, that order, impugn order is at page 43. Lordship can find it, annexure 3, page 43. Next
You are
page.
referring to 4.1?
Yes, my lord, that page 44, that is 4.1.
4.1 of the order?
Yes, my lord. Impugn order, my lord.
Of the order on single judge.
My lord, the direction of the tribunal so passed in all those original applications reflected in para 16 and 17 are reproduced hereunder. Those who have been illegally appointed as Shiksha Karmis and have been observed as primary school teacher cannot continue as primary school teacher since I have set aside their appointment as Shiksha Karmis. This is on the principle that the base having derailed, the superstructure will also collapse, but during their continuance of Shiksha Karmis, they shall be entitled to monthly remuneration of rupees 600. A Shiksha Karmi which they would have drawn bid for the termination by this order. In conclusion, meritorious candidates from out of 607 candidates selected shall be given appointment as primary school teacher in place of those who have been irregularly appointed as primary school teacher by order of the District Inspector of Schools dated 13/12/1996. On the appointment having given to the irregularly appointed teachers who have been regularly shall stand terminated. Till termination of the Shiksha, irregular appointed Krishna shall continue on ad hoc basis on a monthly remuneration. Then this order was challenged before this honorable court. Next page, para 4.2.
4.2.
Yes. That the order passed by this honorable court has been quoted. Page 45. The state, my first paragraph, the state government is required to terminate the appointment of all those persons as primary school teacher whose merit position in 1991 panel does not justify such appointment. Then, if necessary, the state government may give the individual employee an opportunity of placing a document before terminating the employment on the basis of tribunal order date 13/12/96. This was the direction. The other direction, on the basis of the first direction, the service was terminated.
Yes.
This service was terminated in the year 2002.
Service terminated in 2022.
2002, my. The date I am giving that 6/4/2002.
Yes.
After her termination, he appeared in another recruitment test and he was selected in the year 2005.
Yes.
And was also selected on appointed as on 4/1/2005 and regularized on 4/1/2011. This is the subsequent development to his termination. That termination order was challenged before this honorable court in that is way number 928 of 2002. After transfer to this honorable court, this has been disposed upon the holding that since no opportunity has been given, the termination is bad.
No, that 6/4/2002 order.
Yes, madam. See, I have shown my that page 44.
This order has been held to be bad.
Yes, ma'am. That termination order, that for 2002 order has been declared as bad. That my honorable single just interpretation is that
this order has been held to be illegal by which order?
By order dated by 13/3/2023 by on that page 43 annexure 3, my lord. Yes, that is impugned in this case. The conclusion is that this honorable court has directed after giving them opportunity to disengage them. Our case that was not the direction. Direction was to terminate them. If yes, my lord, and
was to give them opportunity.
No, my lord, I am reading, my lord. The state government is of all those persons as primary school teacher whose merit position in 1991 panel does not justify such appointment. My lord, that there is a full stop. If necessary, if necessary, state government may give the individual employee. And he has not taken the stand.
Just a minute, you are reading which paragraph?
I am 4.2, my lord, your lordship.
4.2, yes.
The court of order of the honorable court, my lord.
If necessary.
My lord. First, your lordship. 4.2, page 45. While upholding the judgment passed by on 13/12, made the following clarification. The state government is required to terminate the appointment of all those persons as primary school teachers whose merit position 1991 panel does not justify such appointment. Then there is a full stop. Then, if necessary, the state government may give the individual an opportunity of placing this document before terminating on the basis of tribunal's order 13/12/1996. And he has not made out a case by such termination his position was above, but he has been illegally terminated.
But the order is up to 6.1. I think we challenge that. You could have implemented it. Simply by saying that this is the reason why your
why we are in fact, he was terminated in 2002. Again, he was appointed in 2005, my lord. And in response to 2005, he has been regularized, my lord. He has been regularized. But if this termination goes, my lord.
See, if the termination is illegal, it will have to go.
Even
which post was he holding on in 2002?
My assistant teacher. Appointed as Shiksha Karmi. On completion of 6 years of service, they are regularized as assistant teacher. Your lordship has held.
As the post of assistant teacher is a regular post under the government or not?
Yes, ma'am.
How can you terminate?
By your lordship directed to terminate all those because their appointment is illegal. So, the division bench of this honorable court has held that. Your lordship, I am reading for. The state government is required to terminate the appointment of all those persons appointed as a primary school whose merit position 91 panel does not justify such appointment.
Has been fraudulently obtained. All right.
Yes, ma'am.
Even in that case, you are not required to go through the departmental proceeding or anything, but you will have to tell him. Let's see, this is the reason why your service is required to be terminated.
Yes, ma'am. I got.
And this is a simple thing, and it's a formality.
Yes,
and we understand that it's a formality, but that was to be followed.
But because of this, my lord's observation direction, we have terminated.
You terminated, all right, but now he is saying that you terminated. Did the court say that without following the principles of natural justice, you should terminate?
My lord, he has not made out a case. If he would have been given that opportunity, how can he develop his case that his position was not in the merit list? It was not his case. I am saying, in other words, well, if he would have been given an opportunity.
Yes. What benefit will you get?
Page 32 of the writ appeal, my lord. Page 32 of the writ appeal. 1991, my lord, a 617 list was prepared of Shiksha Karmi. In 1992, I was appointed as a Shiksha Karmi.
No, Mr. Is this your case that persons above you were not appointed?
Exactly, that is my case, page 32. Para 10 of the original application, which was subsequently transferred to this honorable court. My position in the merit list is 139. persons below to my position?
No, that is not the question. If you say that all persons up to from 1 to 137, they were appointed, you have a case.
That is my case, my lord.
Oh, see, just tell us from the record.
My lord.
Tell us from the record.
May
Page 32, yes.
that it would not be out of place to mention here. So far as the Salipur Education District is concerned, there are 360 posts of Shiksha Karmis available for which unemployment was.
You are reading which paragraph?
Roman 10.
Roman 10, yes.
Yes. But
it would not be.
It would not be out of place to mention here. So far as the Salipur Education District is concerned, there are 360 posts of Shiksha Karmi available for which an employment was made in the year 1991. Prior to employment of 91, 188 posts were filled up, and there are vacancy of 181 posts and directed by the Honorable High Court. Since such appointment was to be given strictly in merit list prepared as per 1991 empanel list, and since the petitioner's position is serial number 139, the petitioner in any event is entitled to get the post of the primary school teacher either much before the order passed by the Honorable Tribunal by Annex 3 and or the order passed by this Honorable Annex 5. And now I will kindly see. Yep, no. The read of the application which was the order which was challenged by that is the record is available. My case is, my lord, before the Honorable Single Judge. I was appointed in 1992, my lord.
No, Mr. You are in a position to demonstrate that all persons above you were appointed and no person below you was appointed. That is different. Otherwise, there is clear finding that your services should be terminated.
Well, that instruction I will.
What instruction?
Because my lord, my son
You
all
cannot improve your case.
my lord,
now.
all persons above petitioner, my lord, serial 1 to serial 138, they were all appointed, my lord. And persons below to the petitioners were also appointed.
That is immaterial.
My lord, persons below to the petitioners also appointed, my lord. That is why, my lord, kindly see the page 44, my lord.
Yes, so that is why pick on the basis of pick and choose the appointments have been, therefore all the appointments have been held to be illegal.
My lord, that is why, my lord, Honorable Court said that a notice is to be given, my lord, to the petitioner, my lord, since he was appointed in 1992.
What notice? What is your reply?
Well,
Let us
my
understand. If you have any reply, we will dismiss the appeal.
With
But
regard
you don't have any.
with regard to persons appointed from serial number 1 to 138, I'll kind 2 days time I will obtain instruction.
2 days time.
2 days time.
And if you fail, then
I will pass it.
no. Then what will you do?
I have my information
Now,
that
suppose you are satisfied on the basis of instructions
No.
that the persons of higher merit were not appointed. Then what will you do?
My
Then in that case, so-called becomes meaningless. And then in that case, what will you do?
in that event, my lord may pass order, my lord, I have no objection.
Why the my lord should pass order? You can withdraw the writ petition. Huh? No, writ petition you can withdraw. All right. This matter on Tuesday.
Next week, my lord, Tuesday.
Tuesday. Instructions from line person above him in the list was not appointed, not engaged as Shiksha
Karmi, that primary school teacher.
as primary school teacher in
1992, my lord.
in 1990.
92 onwards.
Based on merit is in question.
Item number 8.
Simple and unnecessary litigation should not be there. If you have a case, all right. If you don't have, and since you are already working, therefore, otherwise the matter would have been different.
See, last
Item number
occasion, last occasion on proposal of my Lord and Senior, we are going to compromise the matter in out of the court, but the compromise has not been done. The more time required to compromise the matter outside the court.
What happened in this case, last occasion, my Lord and Judge says that by passing the order by the Lord and review officer, no land has been allocated in their favor. Inadvertently has been recorded in the name of the present of this number 3. That's why my Lord and Senior State Counsel, they should be settled the matter outside the court and file an affidavit. But in fact, your Lordship may kindly see the order passed by the revenue officer, how much land they have settled in respect of 3 brothers.
No, but
In sealing case.
what I understood from the order of the learned single judge, it has been equally divided between
Yes,
3
yes,
brothers.
yes.
Only name of the mother-in-law has been recorded along with the daughter-in-law.
Yes.
So when she asked for deletion of that name, yes, when you asked for deletion of the name and that was allowed, they said that we have a share in her property because she is the mother.
Exactly. And they filed petition.
So what compromise I can't
Confirming
understand.
the order of the Lord and Commissioner
Okay.
settlement.
No
And that's it.
compromise is required. Single judge order should be upheld.
All right, we are discussing it.
There's no problem, you have your share. Probably he had not understood, now he has understood. it.
This is the order of the review officer.
Understood, and maybe client had also advised that you take a chance in case we get something more. Yes. So why are there 2 petitions?
Two khatas in respect of 2 khatas, that's why 2 the connected. Common order was passed.
Item 9.
Disposed of, dismissed. Order of the learned single judge is upheld. The this
additional
petition is
affidavit
dismissed,
filed.
all right? Since all of you have got shares.
Well, additional affidavit, I will file mail today. 2 weeks time may be granted mail for hearing.
Why? Do you have any right to file additional affidavit?
This may.
Yes. Which law? What is this matter about?
My lord,
What is this matter about?
we have challenged the virus mail.
Virus.
Mail.
So there is no affidavit required for virus. Only law is needed. No law is to be brought on record by way of affidavit.
And last occasion instructed to file the additional affidavit, my lord.
Let us see your challenge virus or what.
One month back. What have you challenged? What have you challenged?
Pass over, my lord.
See, not even for a second, sir. We have been adjourning the matter regularly from 10/7/2024. At your instance. It's not done. So many adjournments, and you are challenging the virus. You are not serious.
Taken up 2 more, my lord.
Where is Mr. Sahu? You had told him that you'll adjourn the
No,
matter.
no.
Then where is?
Who has to?
What is this matter?
My lord, I have not ready. Mr. Swai will do this matter.
What is this matter?
He is challenging the resolution that wherein they are declared as ex-cadre, because there is no rule for regularization of Ganashikya. Government made a policy decision to declare them as ex-cadre so that they will continue in their service. They are challenging that.
So that can be certified. If we certify that.
That is in their interest, they're challenging that.
They are saying that regularize as regular teacher instead of they will be placed in that ex-cadre.
We also, an adjournment is being sought. We are dismissing it. Later you may do whatever you want. An adjournment is being sought. On behalf of the petitioners. From the order sheet, it transpired that at the behest of the petitioner, the matter has been adjourned on several dates by way of last indulgence. Matter is adjourned to next Tuesday to be listed within first 10 cases. It is made clear that the court shall not grant any further adjournment and shall consider dismissing the petition and consider passing appropriate orders to the next day if further adjournment is sought. Seven and eight.
Seven, 8 cases.
7, 8. Yes.
Item number 10.
You are Mr. Pradhan? No. You are Mr.
PK Mahapatra.
PK?
Mahapatra.
May I please, Your Lordship? No, I am challenging here the inquiry report, unilateral inquiry report against me.
Inquiry report is not challenged.
Inquiry report, because of the inquiry report, this demand has been issued. This inquiry report has been drawn against me without any due intimation to me and violating the principle of natural justice.
Where is that?
Your Lordship may see the page 30, the inquiry. As per scheduled program, we following signatories conduct a spot visit to the, that is on such and such, on illegal lifting of transporting of minor minerals, ordinary earth and morum by Shanti Construction Private Limited. I am Shanti Construction. On one inquiry, it is found that the Shanti Construction Private Limited was allowed through temporary lease to lift such and such earth and such, my lord. This inquiry was done against me, but without giving any intimation to me, my lord. And a report has been prepared against me on that basis of that, my lord. Now the demand has been, my lord, raised against me, my lord. My simple prayer is, my lord, a fresh inquiry be made so that in my presence the inquiry may be done, and I have not, my lord. In fact, my lord, the work which I had undertaken, that was terminated because I could not, my lord, perform the work. I have not lifted anything, and the railway contract, that contract has been rescinded, my lord, terminated, my lord, because I could not perform, my lord. Now.
Petitioner is a railway contractor, my lord. He was interested to construct the third line of, Lordship kindly see the page 30 itself, my lord. He was allowed to remove 2000 cubic meter ordinary sand, earth, my lord, whereas he has removed 260,580 cubic meter. And he is not admitting nothing, my lord. He was allowed to 2000 cubic meter to remove as a temporary permit. Lordship kindly see page 30. Shanti Construction Private Limited, on inquiry, it is found that Shanti Construction Private Limited was allowed through temporary lease to lift 2000 cubic meter ordinary earth.
He is reading the fifth line.
Fifth line.
Fourth line, he is reading the fourth line.
Shanti by construction on inquiry, it is found that Mr. Shanti Construction Private Limited was allowed through temporary lease to lift 2000 cubic meter of ordinary earth from plot number such and such, Kisam Patita under Abadya Jogya Anabadi Khata, PS Tangi for use of the same construction work of Bhadrak Nirgundi third railway link project. But the company has excavated ordinary earth more from plot number 1, area 70 decimal, village such and such, plot number such and such, my lord, including the lease out plot. On verification of record of right of a village Kadai and Mania, it is revealed that plot number 1, area such and such, Kisam Jungle 2 of a village to Kadai stands recorded under Rakhita Katana, and plot number such and such, Kisam Jungle 2. Mania stands recorded under Rakhit Katana. The Kisam land is jungle 2. There is no forest growth as such over the plots except small buses and lying as the Pathar Chatanmal. The range officer present also admitted to the fact field position. On measurement of the excavated area, it is seen that company has illegally excavated approximately 260,580 cubic meter ordinary earth. More from the above.
It is his plea that this report was, this inquiry was conducted behind his back.
My lord, that is his plea, my lord.
And in fact, my lord, your lordship may see the forest ranger, he has also not signed. There is, your lordship may see the
No, he
bottom.
might not have signed, but you were.
I was not intimated at all, my lord.
Yes, you were told. That is what is mentioned in the inquiry report.
No, my lord, that is my specific stand, my lord. I have never been intimated, my lord. Let them show a single document that I was intimated, my lord.
Just a minute.
My
Just a minute.
They say as per scheduled program. So program was not known to you.
My lord.
Come to last three set lines of the set order of the report.
My lord, it is seen that the company has illegally expended a approximate
Last three lines.
During previous field visit.
During previous field visit, the company was asked to stop, but they were never given me any
Where have you
notice.
stated in your petition?
My lord,
Where have you stated in your petition?
that I was never,
That this is incorrect.
my lord.
There is also an order of the Green Tribunal to stop excavation.
Para 7, my lord.
Here, my lord, the subject
Para
matter was before the NGT, my lord. NGT.
That is a separate issue.
No, not the separate issue, my lord.
Well, para 7, my lord. I'll come to that, my lord.
You have not mentioned.
Oh, where have you stated that it is not correct, as has been mentioned in the report, that earlier also you were told to. We are coming back.
My lord.
Item 10.
My lord.
Yes, so
May I?
you have not
My lord.
mentioned that.
My lord, paragraph 1 I have mentioned. What has paragraph 1 I have mentioned? What has happened here, my lord? There is a proceeding against me in the NGT. Against of some, I am also a party to that, my lord. Their state government filed a counter. Their state government filed a counter with this report, my lord. From that, my lord, we came to know such a report has been filed against us, my lord. And we found that the NGT committed a separate committee. That report is not coming forth. There is no such report of the committee considered by the NGT. Now, this report has come to
knowledge of us after the filing of the counter by the state government before the NGT, my lord. Thereafter, we came to know such a report has been, my lord, prepared against us, and on the basis of that, now the demand has been issued.
So the matter is pending before NGT.
NGT,
my lord, there is not a single word with regard to
I have
NGT.
written that, my lord, and your lordship may see the order of the NGT.
Just a minute, where have you said?
My lord, I have said,
About
my
the
lord.
NGT proceeding.
Yes, my lord, I have said, my lord. First paragraph, my lord. First paragraph towards the last, my lord. As well as inquiry only when the state government filed its counter in the original application pending before the Honorable Green Tribunal, Kolkata, my lord.
So you can.
Your lordship may kindly have a glance to the order there. I'll if your lordship says so, I'll go there. But no doubt, no dispute about it. But the NGT constituted committee, that committee has not given any report. Your lordship may see who are the committee, para 15 or.
Plea, Mr. Counsel, whatever plea you are taking here,
My lord.
you can take there before the NGT.
But here is a case of a gross violation of principle of natural justice, my lord.
Of that can be looked into by NGT, and see, it's a very
paragraph. The NGT constituted committee signed senior scientist Odisha State Pollution Control Board.
All this, not in this case. Take all this plea before the NGT.
NGT has passed also restraint order.
Restraint order, let's kindly.
Already terminated, the contract has been terminated. What restraint order?
Contract is a different thing. NGT matter
My
is a different-
contract has been terminated because I could not perform. What to talk about the, now they have invoked my grandson, that is a separate issue. That is separate altogether, my lord. Now, on the, my lord, I have stopped work since long, my lord, because I did not get her. Now, my lord, they have terminated my contract. Now, this is the report against me, which is out for without, my lord, even intimating me, they have prepared this report. And the committee which has been constituted by the NGT, that is not given the report.
So you can take that plea which you are taking, you can take that plea before the NGT.
My lord. That liberty may be given. My lord.
Counsel appearing on behalf of the petitioner after some argument seeks permission.
One thing may I point it out, my lord, that the report ipso facto is incorrect. This because they say that I have, my lord, excavated land, earth from forest land. The forest officer has not given any signature. They have not even called the forest officer.
Same plea, same thing, sir. You can take that plea.
That only, my lord, I pray that may be mentioned in.
If you want us to go through the order, then we can record that.
No, I just want to mention that fact. My lord, it will be, my lord, helpful.
See, don't take risks.
I only pray. I can only pray. I cannot, my lord.
No. We are suggesting that don't take risks. If we take note of your this thing.
Your lordship may give me leave. Yes. I bow down to
If the kism of land is jungle, my lord. If the kism of the land is jungle.
All right.
My lord.
One counsel appearing on behalf of the petitioner after the argument submits that he may be allowed to withdraw this writ petition with her liberty to raise all the grounds taken in the present writ petition to question the demand penalty issued by order dated 16/8/2023, miscellaneous case number 35 of 23, before the
on the basis of the inquiry,
based on an inquiry, comma before inquiry report, inquiry conducted behind his back, comma before the National Green Tribunal, comma a National Green Tribunal in original application number 167/2023/EZ. So this application is disposed of accordingly as withdrawn with the liberty.
Right. I am appearing for the opposite party number 9 and 10.
Please.
What's the role?
Item 11.
May I please, Your Lordship?
In this case, my lord, the present petitioner assailed the illegal order passed by the opposite party number 3, Toujimishi appeal number 1 of 2021. The background of the case, my lord, is like that. The petitioner is the lessee of a quarry list for a period of 5 years. That is commencing from 2017 to 2022.
You are challenging which order?
Challenging, my lord, the order passed by the opposite party number 3 under
Where
annex
is
of-
that? Where is that?
Yes.
Section 9. Which order you have challenged?
Annexure 1, my lord.
Annexure 1. Date, yes.
18
Dated
Page 33, my lord.
dated 18/7/2023.
Every year when demand is being made, he is coming to the High Court.
My lord.
High Court is sending him back that you find appeal.
My lord.
So how many appeals has he filed? Or he filed only one appeal after filing 3 writ petitions?
My lord, appeal and without depositing that
Please no.
amount recorded as per rule 46.
No. Has he filed 1 appeal or 3 appeals? Because he has come to the High Court thrice at least.
My lord. He has filed 1 appeal.
No. I filed 2 appeals, my lord. What happens? In the imputed letter, which are letter dated under annexure.
Mr. Counsel, in the present case, you are challenging this order 18/7/2020.
Yes.
What is the illegality?
Illegality is, my lord. In this case, my lord, the petitioner challenge. Petitioner has a quarry list for a period of 5 years.
Forget fact.
Yes.
What is illegality in the order?
Illegality, my lord, is like that. The opposite parties impose royalties and other charges, ignoring the law, laid down 28 plus 28(10) of the OMC rules. 28(10) says 28, rule 28.
But the appeal has been dismissed on 2 grounds. Main ground is you have not deposited the cost for maintaining the appeal.
I have deposited, my lord.
Not the entire. Some you've deposited and asked that for time to deposit the balance.
No, my lord.
You deposit the entire amount.
With the permission I am submitted.
Due permission of whom?
Yes, my lord. Your lord.
Lordship, kindly see page 142. That is the demand notice.
Yes.
142, demand is 1 crore
Did you
28
prefer
lakhs.
appeal?
Yes, my lord.
Did you prefer appeal against the order?
Yes, collector. The order passed by the sub-collector, there is a provision to file an appeal again to the collector. That is the efficacious remedies against the order of sub-collector under annexure 1, my lord.
Sir, counsel, why are you making this submission? Please see what the reason, paragraph the
Four
paragraph of the order. Please come to 18/7/2020.
Yes, my lord. Page 33. Gone through the provision laid down rule 46(1) of OMC rule 2006. It reveals that any person aggrieved by an
Read this part of Criminal Law 46 as well as case record.
Yes, my lord.
Neither the appellant had deposited the demand amount noticed by Tahsildar, by notice so and so, nor preferred an appeal before the collector. So you had not preferred appeal before the collector.
What happened, my lord? May I I have deposited the amount for which I preferred a second appeal before the sub collector because the order, may I permit to read? Page 135 to 141, my lord. The sub collector said the opposite party.
All right, this order was passed because of some order passed in WPC.
WPC, they have directed to prefer an appeal.
2019.
19.
Yes.
Thereafter, I filed an appeal before the office of the opposite party number 3.
When?
2019. Again, in the said appeal, the opposite party said you deposited the amount, demanded amount, then file a fresh appeal. Again, I filed the another Toujimishi appeal in number 01 of 2021 by depositing by complied the provisions of 46 clause 2. That is the Again, I filed the Toji appeal 01 of 2021, and that is the disposal of under annexure 1. Unless until I deposited the requisite amount, demanded amount, I cannot file the second Toji appeal before the office of opposite party number 3.
That is Toji Appeal 1 of 2019, that is 1 of 2020.
21, yes.
21, yes.
After
Different demands for different years.
No. There's no.
I'm mistaken. Different demands for different years. She's saying no.
That is the order I passed.
Lordship, kindly see the order itself. My lord, the impugned
What
order.
order did you pass?
Yes.
Itself, or impugned order, my lord, there is a demand 5/2/2019.
File your affidavit.
This is not maintainable,
my lord.
Because he has
the
not.
order which I did on 41 page. The appellant is directed. The appellant is directed to deposit the demand amount, if any, before the respondent office and before an appeal of this court, means the court of the opposite party number 3, a fresh hearing. Thereafter, I depositing the entire demanded amount, file and fresh appeal, that is Toji appeal number 01 of 2021. That is the disposal which is assailing under annexure 1. I deposited the amount. Unless deposited, the second appeal cannot be admitted.
Demands for different years. So you will deposit of 1 year and ask for.
Lordship, kindly see the impugned order for the moment, my lord. Page 33. 33, my lord. The rule 46(2) is quoted, my lord.
Yes.
Then the next, my lord, on perusal of the rule 46(1)(2) of OM's rule 2016 as well as the case record, neither the appellant has deposited demand amount noticed by the Tahsildar Bosta by notice number 372 dated 5/2/2019, nor preferred any appeal before the collector. And this letter he has not enclosed this demand, my lord.
Yes.
5/2/2019. And lordship, kindly see the page. There is another demand, my lord.
No, that letter is enclosed. It is annexure 6.
5/2/2019, my lord.
Yes, annexure 6.
My lord. And he has not stated where he has deposited this amount, my lord. Where you have deposited?
Yes. In the order, my lord.
Not in the order. Where have you deposited? Where is your averment?
Yes.
49 lakhs.
1,27 lakhs I have been paid, which is in contract as per the for admission of the appeal, complying with the provision 46(2). Thereafter, file the second appeal with the direction of in obedience of this honorable court to file another appeal before the competent authority for the redressal.
What is second appeal?
Second appeal, my lord, Toji appeal 01 of 2021.
Second appeal means an appeal against an order passed by an appellate authority.
Appellate, no. That order passed
Then
by
why
the.
are you saying the second appeal?
No.
Second appeal.
That is the afresh appeal for the same office.
Try to make us understand.
Lord, may I peruse one paragraph line of the 141 page, my lord. 141 page, internal 41 page. The appellant is directed to deposit the demanded amount, if any, before the respondent and prefer appeal before this court. This court means the opposite party number 3, afresh for hearing. That is the order passed by the Toji appeal of 01 of 2019. The afresh appeal is 01 of 2021. That has been disposed of by the opposite party number 3, which is assailing under annexure 1. After unless until I deposited complied the clause provision of 46 clause 2, the afresh appeal cannot be admitted before the opposite party number office. That is, admittedly I deposited the amount. This appeal has been duly admitted, and the office of the opposite party number 3 disposed of the same, which I assailed in the annexure 1, below. In the annexure 1, they stated only a single page order. They are not assailing by the grounds of the appeal, which I haven't taken. In the appeal memo before the Toji appeal, they simply stated, my lord, gone through the provision laid down under 46(1) of the OMS rule, any person aggrieved by an order of the competent authority.
That we have read 10 times.
Yes.
That order we have read. So we will see what can be done on Tuesday.
Sir, what happens, my lord? Just 1 minute, my lord. I have a quarry list. Apprehending less quantity of minerals I applied for modification of mining plan, and the modification of mining plan is duly approved by the committee.
All right, let us read, then you will clarify. All right. We'll pass order from Tuesday. Third land council was it. This matter will be hearing on Tuesday.
Item 12.
Item number 12, pursuant to a lawsuit direction dated 14/8/2024 and 28/8/24, the authorities have taken a decision on Annex 11 submitted by the petitioner nurse in the form of a show cause nurse. The order was passed on 3rd of September this month, nurse. So if my friend has been served a copy or not, I don't know if he has not.
No, they have not served copy on me, Lordship, but what are they? They should file with the affidavit, Lordship, what they have taken decision. Personal
No,
Lordship.
if they have communicated.
No,
to
no,
you-
Lordship, they have not communicated.
But they say that it has been communicated through mail. But if my friend doesn't have, I can give a copy to my
What is the
friend.
date? What is the date of communication?
Date is not 4th September 2024.
Let me serve
You,
the
ha-
copy.
you have a copy of the mail?
Yes, let
Yes,
Then give it.
kindly hand me a copy. I can-
Mail so far also
No,
restored.
you are saying that you have
Not
not received,
received.
record that.
No, Lordship, we have not.
I can give a copy to my friend also, Lords. The order I can also.
Order is also there.
Yes, everything is there.
So it is in his favor, then there is no problem.
No, his representation has been rejected, my lords.
My Lordship, kindly see Annex 6. What is my
No, no,
attention?
we'll see later.
Lordship.
First we'll see the mail.
First, we will see, you consider your statement that you have not received.
Call up your client and ask if he has received
Lordship.
or not.
In fact, Lordship, yesterday I have contacted.
Learned AGA
Is there any communication? No.
representing the opposite
Email.
parties. has
But Lordship,
submitted-
kindly see, that is the whole difficulty in the writ application, Lordship. For us.
has
Day one, I have Lordship convinced Lordship. The language say Lordship, it has to be communicated by register. That is the finality. Lordship, kindly come to page 44. That is the entire
Will
Lordship.
you
My
permit us to write dictate
no,
order
sorry, Lordship. I'm answering on Lord Justice, Lordship.
in the meanwhile?
No, Lordship, sorry, Lordship, because my Lord pose a question, Lord, that I'm answering, Lordship.
I have not posted any question. I
No.
made a statement that you've not checked your
No,
mail.
sorry, Lordship, extremely sorry, then, Lordship.
And then AGA representing the opposite parties has submitted that the office of the additional chief engineer, that office of additional chief engineer, Rengali Right Irrigation Circle, Chaudhar Katak, has communicated to the petitioner through letter number 622 dated 3/9/2024, through an email.
So also registered post, Lords. Registered post is also next page.
21. Dated 6/21. Email to the petitioner rejecting the petitioner's disposing of the petitioner's representation from the counsel appearing on behalf of the petitioner states that the petitioner has not received any such email.
Yes.
Stop. Whether email was sent.
That is the.
Let an affidavit be filed by the additional affidavit be filed by the petitioner stating that he had not received any email on his email ID alokpanda92@yahoo.com. the additional affidavit must be filed by Tuesday.
If lordship is same liberty, if they I received then liberty to file challenge the same lordship.
No, we will first see.
Lordship.
Whatever statement is made before this court, that statement must be true. And if that statement is not true, the court will pass appropriate orders.
But lordship, at the same time, lordship should see also lordship.
We will consider
They've
everything.
sent it through registered post to AD lordship.
All right. You said that you have not received any communication. through
Lordship,
email.
I have
Your client informed
yesterday
me.
I have contacted to my client, record my statement, lordship. I have contacted my client. He made a statement. He had been to office. Office said, lordship, this matter is sub judice before Honorable High Court. If result will come out, then we'll communicate. That is the statement of the
All right, you will take that.
lordship. But email common is a technicality, lordship.
No, Mr. That is not that. You can say that email is not the proper communication.
Lordship,
but
that
but your statement is he has not received. the
Lordship,
email.
lordship, because I had yesterday I have an
All
input
right.
matter.
As per your
If that is so, that
instructions, no problem.
lordship may not be verified, lordship, email, lordship. Email is not a proper communication, lordship, because we expect, lordship, because tender condition says it has to be communicated by register for the AD. So we expect, lordship, it has to be communicated to me by register for the AD, lordship.
Mr.
That is,
Counsel, please keep in mind
lordship,
that whatever you say,
Lordship.
standing there, we believe that
definitely,
to
lordship.
be true. All right, whatever, we presume that what is being said from there is correct, unless it is found otherwise. So if you make even if you make a casual statement, please be careful that that statement is not factually incorrect. This is.
And that's true, lordship. But we'll try our best, lordship. But lordship, our humble submission.
All right, we'll see. We'll see on Tuesday.
Item 13.
There's one more line. We have also signed it to registered post.
It's written on top. That in the meanwhile you may have.
If that is this, is definitely come with affidavit, lordship. I'll verify, lordship. Email also.
Item 13, in the nursing matter, last on 4th of September, it came. I had prayed for 2 weeks time because 17 matters are there. I have to get instruction and file the count. And that's why I want that this matter is similar to that of the 52, 51, 52, wherein the deficiency was complied in late, not in time. So my prayer is let all these matters, I have given the list, come on 19th. Before that, wherever I will file the counter, I will file the counter. And where I have to adopt the same counters for other cases, I will do. Because there are 21 counters I have to file again in the new cases. My
How
prayer is
many total nursing colleges are there in Orissa?
more than 300, my lord.
And all of them have approached the court.
No, my lord. We have given NOC to so many colleges because there was previously some restriction. In the last year that restriction is over. They have took it out. Some lot of institutions are coming out.
And ordinary colleges that imparting different subjects.
ANM, GNM, and BSc nursing, BBBSc nursing.
MSc nursing, physiotherapy.
Some colleges, some institutions.
Number 13, my respected senior is making submission here, are covered by your lordship order in synergy case. In my case, it is covered. He has to obtain instruction to that extent. Otherwise, if your lordship will permit me for 2 minutes, I will satisfy it is covered by your lordship order.
You may satisfy me, but without giving him an opportunity to
Yes, my lord.
consider this.
To that extent,
We shall
instruction
not
as-
pass any order, not
Yes.
on the basis of what you have stated. Any order cannot be passed.
Let all these matters come on 19th because that is a full day court. My lord, supposed to be there.
Requested on behalf of the DMET, list these matters on 19th, so as to enable him to seek instructions and file counter affidavits if so required.
My lord, 51, 52, 53, 54, 56, all they are same. I've given the list.
At item 53, sub item 1.
51, You said 51, 53.
The readings are all over. Readings are all over in that matter. Can be taken up at a date, as your lordship will be pleased to fix.
19th, we can take up.
Yes, ma'am.
19th, you point out.
All
Right.
this, I have written that. Numbers are.
53 sub item number 1.
53 your file counter.
Yes.
53 I have already counted.
Such matters which can be disposed of.
Yes, ma'am.
On
I get
19th, we shall dispose of.
Yes.
Right.
Such matters where argument is required, we shall hear and we shall discuss.
Yes, ma'am. 19.
Lots.
But
Lordship
we
may
shall
direct.
set aside such application. So you should, all of you should be very particular about it. That according to DMET, they are not entitled. According to them, they are entitled. That will.
The point will be very precise. Very precise. Only that period which I have taken to comply with the defects, if they can condone, then we have a case. If they will not condone, then we don't have a case.
The Lordship may
Very
direct
fair.
Lord Council for DMA to solve the coffin in advance, enabling us to file our response.
So when did you file your writ petition?
Since long, July, in the month of July.
July.
And some of the cases.
Most of the cases I have filed a counter, my lord. In some cases recently given because that is a problem.
Just you cannot ignore the contribution of Mr. Mohanty in disposal of all the matters.
17 cases counter I am every day I am making 4 5.
All right, we understand your predicament. All right.
19 will do, man. So grateful.
In this case, transfer as a general already agreed. I have filed additional affidavit.
We will see on 19th. We will see on 19th. File in the registry. Not yet.
File and see that it reaches the record. If you can ensure, because we are not able to ensure.
Copy should be given to me and.
Yes, I appear in 54 sub item number 4.
All the cases I have given the number.
Item number 14.
Challenge in this case is to the validity of the notifications issued by the CBIC invoking the provisions of section 168A of the GST Act, my lord. My lord, in this present case relates to 1819, my lord. In similar batch of cases, my lord, your lordship had directed the Revenue Council to file an affidavit stating whether that notification is backed by the recommendation of the council or not. And your lordship had have granted interim protection. I pray, my lord, similar protection and to be
Lordship, let
tagged
it be,
along with the
let it be tagged in those matters, your lordship, those matters likely to come today, but
Yes,
are not listed today since no division bench chapter launch. So, your lordship.
My lord, council appearing on behalf of the petitioner and the council representing GST.
Your lordship,
Department, your department. is also
I'm per opposite but no 5 and 6 state GST.
opposite party number.
I'm for opposite party number 3 of us.
That and opposite party number 3. That identical issue is involved in
17340 of 24, ma'am.
One 17340 of 2024 and other connected matters. From the said cases on 11/9, those matters.
Your
are-
lordship, today those matters have been fixed after 2 p.m. at 2 p.m. But I think there will be no division bench for those that reason.
List this matter on
Today morning also both
list
the
this matter along with WPC number 17340 of 2024 and other connected matters.
The lordship permits, may I make one more prayer, my lord. Similar writ petitions.
Interim order we can give it.
What is the interim order?
Interim order, my lord, no coercive action pursuant to the adjudication orders, my lord.
We will do it tomorrow.
My
Gratefully.
Item number 15.
May I please? Petitioner has challenged the tender call notice in which two conditions has been stipulated, which is not prescribed under law, my lord. My lord, may I permit to, the tender was fixed to, last date has been fixed to 22/8. Thereafter, it has been extended to 12/9, my lord. My lord. Your lordship may see page 16, clause 9. This is a transportation contract for midday meal, my lord.
You are challenging which?
Clause 9, my lord. Basically, clause 9 and 6. Clause 9, your lordship may see. Just to clarify that one. Valid
Clarification can be done before the committee.
My committee has, there is no provision for pre-bid meeting. And the valid agent license from the competent authority shall be furnished along with the tender. Within bracket, RTO is competent to grant such license where agent intends to carry on his business within one region, and STA is a competent authority where agent intends to carry on business in more than one region, my lord. That is not there in the law, my lord. Yes. Similarly,
Maybe there may not.
no,
be
my
there
lord.
in
Your
the
lordship
law,
may see page 22 for a moment. Page 22. The same thing they have asked for, the certificate they have asked for the transport license, my lord, which is necessary for do the transportation work, my lord. Clause 3, page 22, clause 3, serial number 3. In the checklist, it has been stated what to be submitted, my lord. Attest, page 22.
Yes.
My lord. Attested copy of valid agent license under Carriage by Road Act 2007 and Carriage by Road Rule 2011. The lordship may see Carriage by Road Act 2011. It has been stated how the license will be given and what will be the license, my lord. There is no provision to give license by RTO for the district and for STA for the state, my lord.
Where
For
do you have the?
So you are saying the checklist is at variance
The
with that
the
clause?
variation is there. In checklist, another thing they are saying, and in the clause 9, they have saying another thing. They have to clarify it only. And another condition I have challenged, though it is, the AMD has been fixed to 2,50,000. Now, after having purchased, they have stated 2%, but not 2%.
Tomorrow.
By tomorrow.
Tomorrow we will seek instructions.
If there is any clarification, your lordship, then they might issue a corrigendum to the tender and
Because
clarify.
tomorrow is the last date.
Yes, your lordship.
So first
So therefore-
5 cases.
Yes, your lordship. I will,
Seek instructions.
yes, your lordship.
All right.
Discuss matter. Tomorrow, in first 5 cases. So it is expected that the AGA shall seek instructions in the meanwhile on the point of the requirement of submission of valid agent license, as prescribed under paragraph 9 of the eligibility criteria of the bidder. The open tender notice dated 3/8/2024. Annexure 1. What is that?
Annexure 2.
Annexure 2.
Right.
Annexure 1, my license, my lord. Vis-a-vis clause.
According to the petitioner, paragraph 9 of the tender notice is not in consonance with the
Carriage by Road Act.
corresponding requirement under the checklist, which is at page 10.
10 of the tender call notice.
Tender call notice. Yes.
Item number 16.
I have plead your lordships. Because this is a tender matter where the writ petitioner is held to bidder. Now, Miller, we are challenging the status, Miller, given to the opposite party number 3 as the L1. And also we are seeking a declaration that OP number 3 is ineligible for suppression and for concealment of material facts. So, Miller, this is a case, Miller, your lordship kindly see the tender is for the operation and management of patient transport. This is the ambulance service, that is 108, that is for the state of Orissa. In fact, I am the operator for the last 2 terms, 11 years. You kindly see what are the requirements and how he has not given those material facts for which there is a suppression of material facts, and there is eligibility because he was blacklisted in Karnataka, and now there is a proceeding pending before the Jharkhand. Now Meghalaya has also terminated that. So 3 states he has got this. So that I want to show which was not taken into consideration.
And you are L2.
I am the L2. And there is a provision, Miller, that Miller, L1, they will negotiate with me if L1 is not suitable. So that is what, Miller, my right comes there, 3.3.2, Miller.
Yes, so is for the state.
Yes, I am for the state.
I am
for respondent number 3, caveat, Miller. I am the successful party, Miller, respondent number 3.
Just a minute. Yes.
I am a caveator.
Just a minute.
I am appearing for the opposite party number 2, my lord. My Vakalatnama, my lord, I have filed, but it is not there on record.
Your opposite part number 2 is?
2, my lord. The National Health Mission, which has floated the tender, my lord.
I'm for the one state, my lord. I'm for the state.
So have you gone through the,
my lord,
the allegation?
I have filed the Vakalatnama day for yesterday, my lord.
So
They have not served me. They have not served me a copy, but yesterday night I downloaded the copy, my lord. Let them serve me a copy of this.
Do you have a copy, Mr. Mishra?
Yes, I do, Milord. If your lordship give me, Milord, if your lordship by the clock give me, Milord, 2 or 3 minutes, Milord, no more than that, I'll show your lordship. Milord, 10 years, this party, Milord, has not only had the butter and jam, Milord, they've got the entire bakery, Milord, in their pockets. And I'll show your lordship, Milord, that it's time that they gave up now, not come to your lordship with these completely frivolous claims, Milord. Let a new party come in. I'll show your lordship 3 compelling reasons why, Milord, this writ, your lordship will at the threshold dismiss, Milord, with the greatest respect.
Yes, Mr. Mishra. So, should we?
May I show your lordship, Milord, why this deserves to be dismissed? Complete lie, Milord, to say that I have been either blacklisted or, Milord, kindly see if your lordship will just have a look at the synopsis. Just kindly see the synopsis, Milord. The only clause that, Milord, they rely upon is number at page C, 1.2.7. 1.2.7, Milord. The participating
1.2.7.
No,
that's right. The participating entity. Very well. I'll take your lordship to 1.2.5 also, Milord. Your lordship will find that at page 43 of their writ petition. One entity, 1 should not be insolvent in receivership, bankrupt, or being wound up. That's 1. 2, not having its affairs administered by a court or a judicial officer. Milord, neither of these obviously apply to me. 3, not having its business activities suspended. Your lordship may kindly mark this because I think this is what the emphasis is on. Not having its business activities suspended.
1.2.5 or?
Yes, Milord. 1.2.5 at page 43 of the writ.
Yes.
Milord, your lord, that's the physical brief, Milord. Your lordships are
I can.
I'm grateful. So, Milord, the participating entity, 1 should not be insolvent in receivership, bankrupt, or being wound up. Number 1. Number 2, Milord, not having its affairs administered by a court or a judicial officer. Neither of this obviously applies to me. 3, not having its business activities suspended. my lord, this your lordship may kindly mark. I think that's the reference my learned friend wants to make. But this, my lord, not having its business activities suspended is obviously an allusion to either, my lord, an IBC proceeding or some such proceeding, my lord, a bankruptcy or insolvency proceeding or something. But anyway, be that as it may, your lordship may mark this kindly, my lord. And my lord, 4 must not be subject of legal proceedings for any of the foregoing reasons only, not for any other reason. So this is 1.2.5, my lord. Now, 1.2.7 is right below that, your lordship will see, and that's the emphasis. The entire petition, the emphasis is on 1.2.7. There is no mention of 1.2.5 anywhere, but I read it because my learned friend wanted me to read it. The participating entity should not have been, my lord, blacklisted. Number 1, your lordship may kindly, my lord, mark, or otherwise disqualified pursuant to any debarment. So, my lord, a debarment or a blacklisting. These are the two. Any debarment proceeding by any central or state government, local government or public sector undertaking in India, and which is for the time being in force. My lord, my learned friends have talked about 2 states, my lord. One is Meghalaya, one is, my lord, Karnataka. My lord, I heard your lordship, my lord, in item number 1, I heard your lordship saying, my lord, and taking a very, very, my lord, may I say, stern view of, my lord, where completely false assertions are made on affidavit, my lord, in a writ petition, your lordships. Salutarily, my lord, I said with respect, dismissed it with exemplary cost of 75,000. This, my lord, is a similar case. Because may I tell your lordship why? Because they, my lord, say that Meghalaya, there is a suspension of services. By your lordship may kindly see paragraph page B, my lord, the synopsis. That's the nutshell everywhere. It's been mentioned about 10 places in the writ petition. My lord, the letter, last 10 lines at page B, the letter dated 14/8/24. This is their representation, the representation of the petitioner saying that I should be not considered because of this particular reason. The letter discloses that the apparent suspension of services in Meghalaya and the subsequent termination of the agreement as stated in the government of Meghalaya tender. That's the subsequent tender. My lord, they have annexed the documents. Kindly see the reading of the document. Is this made out? Kindly see this. At page 574 is the document of the Meghalaya government. And I say with respect, it's an egregious lie. My lord, said on affidavit. Kindly see page 574. This is, my lord, dated the 2nd of August 2022. My lord, my contract with the Meghalaya government was up to 30th of June 2022. So this is, my lord, we are looking at 2nd of August 22. My contract was up to 30th June 22. We are now in, my lord, 24. Kindly see the letter. With reference to the subject and letter cited above, since the emergency response service has dial 108 has been disrupted due to the strike called by field staff of your organization, the current MOU with GVK Emery, that is me, has ended on 30th June 22. So, my lord, by efflux of time, my contract expired on 30th June. They asked me to continue, my lord, until a fresh tender was issued. And in view of the above, government has decided to not extend the project and close the project till the new tender process is completed. My lord, is there a word suspended or terminated in this, my lord? By efflux of time, my project is over. They say that please now this, and the next page makes it even more clear. Kindly see, this is 2nd August. On the 8th of August 22, next page, my lord, at page 575, they say, with reference to the subjects also.
What about?
I'll just come to Karnataka in a second, my lord. Just kindly see this. In view of the above, government has decided not to extend and close the project till the new tender process is completed. You are requested to initiate the final settlement of the employees and prepare with required office staff for the closure and handover of the project. So, my lord, no question of suspension, no question of termination. By flux of time, my contract is over. Thank you very much. Come up with a new tender. So, this is the issue. Now, as far as Karnataka is concerned, yes, there was a blacklisting order which was passed against me. I have moved the Karnataka High Court. The Karnataka High Court has stayed the blacklisting, my lord. Now, that is something, my lord, your lordship will kindly find. My lord, there is a annexure in this, my lord, where in the tender document, where, my lord, you will find, your lordship will find an affidavit has to be given on stamp paper at page 142. Now, once again, there is an egregious suspension. What they do is they produce the basic, my lord, the blank template form of the annexure. They don't give the, my lord, exact undertaking that I have given. My undertaking, my lord, and if your lordship like, I can either screen share it, or, my lord, there is somebody in court, my lord, who will be, if your lordships graciously permit, will hand over a physical copy to your lordship, my lord.
No, therefore,
I have,
Mr. Mishra, it's
yes, Lord.
proper. If we take up the matter in the next week, and in the meanwhile, let us be clear on facts. You can file your affidavit. You are showing us a document. Let that come on affidavit, and then we can decide.
The only issue, my lord, may I just only respectfully, my lord, submit, the letter of acceptance has already been given to me. So, my lord, as it is, they have to challenge that now, because, my lord, I have on the 10th of this month, my lord, already got the letter of allotment by the government, my lord. It says, I am directed to inform that after evaluation of the proposal submitted by your organization so-and-so, you have been selected as the preferred bidder for the implementation within the framework for a period of 5 years from the date of signing. So, my lord, I have already got this. So, they have to now amend their petition and challenge this also.
They
so,
may challenge.
I'm sorry, my lord.
They may challenge. They may file.
They may. My only other thing, my lord, in public interest, the reason I said that I prefaced my opening statement by saying for 10 years, my lord, they've had the butter and jam. I'll tell your lordship why. My lord, the rates, the financial bids are open, as your lordships, obviously, since I've got it now. The financial bids show that, my lord, I am offering 2.28 crore per month, kilometer to kilometer, less than what this party has been, my lord, suffering the government of Orissa for the last 10 years. My lord, therefore, we are looking at roughly 30 crores a year. 300 crores in 10 years is what the government of Orissa has lost, thanks to this party who's been operating for the last 10 years. So today I give a offer, my lord, kindly see, my lord, and kindly see how oil prices, this is the 108 ambulance service. Oil prices have gone up from, my lord, 35 rupees to today to 100 rupees.
We will see, Mr. Mishra, on the next.
So, my lord, as long as your lordships, my lord, are not inclined to, my lord, stay anything, let the, my lord, entire process, my lord, continue, because this 108 very well. So whatever, my lord, would your lordship?
We will consider this. Have you filed any application?
Yes, interim application.
We will consider only after the affidavits are filed.
Milord.
All right.
Yes.
I'm very grateful. I'm very grateful. I'm very grateful.
And Milord, now the status, Milord, he has only been declared as the preferred bidder. He has not executed. So therefore, Milord, now the status quo has to be maintained.
No, why?
No, I'm sorry.
Milord?
Why status quo? We will pass interim order if required on the next day.
Yes.
On
yes,
18th.
Yes.
Yes. Right.
Very grateful.
Yes.
Would your lordship give us a week's time to file a counter? Your lordship.
We are giving you
your lordship's permission. My learned senior colleague said that there is no termination.
The what
now,
547?
Now, if your lordship will look at 541, that's the new tender notice which has been. In 547, the words are used terminated.
That I have written to the state of Meghalaya, threatening to sue them. I said I'll sue you for defamation.
Two issues.
We will see, Mr. Every aspect. In fact, it will be better if you give a short synopsis of your case on the next day.
Yes.
Of Mr. Mishra also gives me.
I'll give
and then
yes.
Right. Synopsis so that it may be easy either to grant or decline your interest relief.
May I just pray, just pray that we are operating right now. The contract has not been awarded. So I was just praying if your lordship, whenever date is fixed.
18th we are saying.
Very well. 18th.
Yes. Week beginning, if it's convenient, for your lordships, week beginning 23rd.
18th.
Would your lordship have it on the week beginning 23rd, my lord? Week starting 23rd, if it's convenient.
That is subject to
then their contract will be signed. Everything will be signed.
Because if your lordships are giving us a week, my lord, a week is, and then they'll want to file a rejoinder, I'm sure, because I'll file a counter.
May not file based on your.
I am in some difficulty next week for 2 days, my lord. So if it's possible, otherwise somebody else will appear. There's no difficulty, my lord. There's no.
They may have a valid this thing ground.
No. So they may not get whatever date your lordship's giving, my lord. I have
Come
no.
on, 18, Mr. Mishra. Let us try.
Very well. Very well. Very well. Very well. I'm grateful to your lordship.
Matter on the third. Matter on the let's counter proceedings. The counter affidavits we filed on behalf of the opposite party
number 2, madam.
Opposite party number 2, and you are which opposite party?
Three.
Number 3, my lord.
We are opposite party number 3.
Meanwhile, on the next date, the court will consider passing appropriate orders on the petitioner's application seeking interim relief. Yes.
Mr. Mahanti or Pradhan?
Grateful to my lord.
CK Mahanti.
Since my Vakalatnama I have already filed, let my name be reflected. For opposite party.
Reflected. Very great.
Item number 18.
Grateful, my lord.
Please, your lordship. My lord, this is a public interest litigation. My
Item
lord.
18, my lords, I am on caveat. A copy has not been served on me yet.
In a PIL, you file caveat.
My lords, this is a PIL against a notice inviting tender by a PSU.
Did you,
Because
could
they
you
had-
visualize that a PIL?
No, they had sent a letter.
All right, maybe.
Sent a letter, main newspaper.
Oh, all right. What is this PIL about? Just let us very
So they are-
curious about the development. It's about. Sir.
My lord, this is a mineral. My lord, this is a PIL, which is a tender floated for choosing successful bidder who will become a MDO, my lord, mining and development, which will do a development and operation of mineral sands mine in between a patch of land, which is a coastal land between Puri and Brahmagiri.
Just a minute.
18.
And what is the public interest?
My lord, I have demonstrated and displayed all the violations of the MMDR Act, the CRZ regulation, and the atomic mineral rules committed by the authority which has floated it, my lord. And we have given them sufficient representations and also intimation before preparing this PIL.
We have put a different question. What is the public interest? The action of an authority may be violative of any statutory provision, but that itself will not be a public interest, like should be taken in a proceeding under public interest. It depends on whether a person aggrieved can approach.
Or unless non-compliance has some effect on the environment or whatever.
My lord, there is an environmental aspect as well. My lord, may kindly come down to my grounds, my lord. Apart from the violation of the statutory regulations and the statutory rules laid down by the central government, there are also violations with regard to environment. My lord, admittedly, the authority in response in the pre-bid meeting to the queries made by the bidders, they themselves have said, yes, there is violation of CRZ regulation. They have overlapped the land which is already granted by airport authority for development of an airport. Third, all the eco-sensitive zone in and around that place, be it Bali Harchandi, be it Puri, be it other places, there is no inkling of any kind of any kind of precautionary measures provided under the bid tender, my lord, the tender document.
Whether before filing of PIL,
My lord.
you have examined Odisha High Court Public Interest Litigation Rules
Yes,
2010.
exactly, my lord. Rule 8 I have complied, my lord.
You have complied with.
Yes. I have Rule 8 I have complied, both paper publication plus representation I have given. After the representation, before filing the PIL also I have given the intimation. I have completely complied with Rule 8, my lord, which is at para number 28 of my petition. At page number 16, my lord. At page 16, para 28 onwards is the compliance of Rule 8, my lord, along with the annexures. My lord, very, very serious issue, my lord, because, my lord, these are the kind of minerals, atomic minerals, which cannot be done by anyone but by the central government and its corporations. So therefore, the standard which is.
And who are you?
I am the PSU, my lord.
I am, my lord,
who has issued the tender, OP number 3, IREL. That is a PSU under the Ministry of Atomic Energy. It is one of the only, the only PSU which is authorized to do the atomic mining. Atomic mining is nothing but only beads and minerals are taken, that is segregated, and atomic minerals are then segregated and produced. That is very important in terms of the strategic requirement of the nation, my lords. That is why the present caveat I have filed. All as per my instruction, all compliances have been done. This is a premature PIL challenging the NIT. NIT says the scope of work, there has to be a further exploration as to what can be done.
Why do you say premature? That after exploration, these issues may arise?
My lord, if at all, there is no violation as such, because all these compliances and everything that has to be carried on during the exploration.
File your affidavit, that can be done. We'll see later. Mr. So and so accepts notice on behalf of. Oh, okay. How much time will you take?
3 weeks time, because the head office is in Mumbai and there is an office in Berhampur.
I requested on behalf of the opposite party number
3.
This is matter on 3 weeks, so as to enable him to seek instructions and file counter affidavit if so required. Yes.
Item 19.
Obliged.
19, my lord, I beg to appear on behalf of the writ petitioner, my lord. My lord, am I audible, my lord?
Yes.
Yes, my lord. My lord, petitioner is a my lord, law student. My lord, he is pursuing his course from my lord, Madhusudan Law University. And one of his college, that is my lord, called my lord, Gangadhar Mahapatra Law College. My lord, this year, my lord, he appeared for the 6th semester, which is mediation paper, and he failed to my lord, secure the my lord, pass mark. Immediately, my lord, thereafter, my lord, petitioner, my lord, under my lord, section 6 of the Right to Information Act, my lord, asks for my lord, 2 things. One is my lord, for evaluated answer script. Second one, my lord, for my lord, model answer paper. My lord, kindly sees their reply. That is completely contrary to the rule. My lord, no, that is not objective. Theoretic paper is there, and also my lord.
What is the reply?
My lord,
what is the reply?
What
is your relief?
Relief, my lord, I am seeking, my lord, right now, my lord, because kindly see my lord, I am, my lord, I am immediately thereafter, my lord, there is, my lord, their rule says that 3 months, my lord, has to be, my lord, they have to wait for 3 months for evaluation of the paper. Without giving that opportunity to me, my lord, immediately they have, my lord, declared the examination.
Declared what?
Declared the examination for the students. That, my lord, completely depriving my right to see my answer script along with, my lord, model answer script. My lord, kindly see the reply there.
Where is the requirement of
Kindly, my lord,
model
take
answer? Where is the
Hello?
requirement of model answer?
Model answer there, my lord, rule says that. Their rule says that there is a model answer here. My lord, may I take, my lord, kindly take trouble to, my lord. Model answer.
Page number 98.
Yes, 98, my lord, kindly says.
Page 98.
Page 98.
Which annexure?
98, my lord.
Which
annexure, my lord, function and responsibility.
Annexure 6.
My lord, 2, small Roman 2, my lord, kindly says. My lord has got it, my lord. Small Roman 2.
Yes.
Page number 98, small Roman 2, it says, on the first day of evaluation of the chief examination shall prepare the scheme of valuation of answers and discuss with the assistant examination working under him
There is
and shall
difference
give the
between
instruction.
What are you saying? You are saying model answers.
Yes.
That is scheme of
It
evaluation.
says so, my lord.
There is
Scheme,
difference
my lord, for
model
the
answer and scheme of evaluation.
My lord, kindly
Scheme
sir,
of
that is for the
valuation
terminologically, my lord, it is different. Sometimes
Terminology.
it says, my lord, sometimes it says, my lord, in the my lord, rule
We
says,
understand
it
the
is a
difference
scheme of
between answers. You don't have to repeat that. Now let us come to the relief which you are seeking.
my lord, kindly says, my lord, their reply.
What is your relief? What do you want?
My lord, I want for my lord, two things. For my lord, my evaluated answer script and my lord, the model answers paper, which I can compare whether there is any wrong done by the my lord examiner or not.
All right. All right. We do not find any merit.
Malik, kindly sees their reply. That is contrary to their own my lord, RTI rules.
RTI rules,
Malad,
then
one
you
Malad,
file an
kindly
appeal under the RTI.
There is no provision of appeal.
Huh?
There is no provision of appeal under their rules, my lord. That's why I'm saying that, my lord.
Under
Kindly
their
says,
rules?
my lord, under their rules, own rules, RTI rules.
Who has framed RTI rules?
That is the RTI rules of the university.
What? RTI rules are there. RTI Act provides for appeal.
Provides for appeal, my lord, your lordship knows that their my lord, authority has to declare who is the appellate authority. And that is my lord, so. In case of the any rejection, my lord, kindly sees their reply.
Even if the rules do not provide, even if the appellate authority is not designated, you can file before the immediate superior authority.
My lord, only one thing, my lord, kindly sees the once they reply, my lord, to the my RTI
We will not
application.
see unnecessary. We are not the appellate authority under the Right to Information Act.
But this, my lord, kindly consider that.
We will not consider the correctness of reply.
There is no alternative remedy, my lord. My lord, will your lordship go to the my lord, their rules, my lord?
No, we are not convinced.
Their rules says, my lord, their answer is contrary to their own.
The boy is unnecessarily wasting his time in the courtroom. He should have studied. Huh?
So the exception, please turn.
We have started with litigation.
It is
These applications deserve to be dismissed with cost. RTI challenging before this court.
So declaration.
My lord, 128 is their reply, my lord. Kindly, my lord, go through it.
We will not. we will not look into the correctness of the information provided to you under the Right to Information Act. That is not within our
Yes.
domain.
Judgment.
Under the act, there is a specific condition.
Hmm? 59, 1 o'clock we will take up. 59. Where is it? Right here.
Item 59.
My lord. My lord, the petitioner appeared in the NEET undergraduate.
Where is
exam.
Mr. Palit? Mr. Palit, had you informed him?
My lord.
Okay.
My lord, from the, my lord, kindly see page 19 of the counter affidavit filed by NTA. Page 19 of the counter affidavit. On the calculation sheet, it became crystal clear that although the petitioner has not attempted question number 148, but it has been evaluated as a wrong question and 5 mark has been deducted.
Counter affidavit is not there. Your
Counter affidavit filed by NTA.
Reply affidavit on behalf of respondent, like C.
This is that BMS course. Is this that BMS course or what? No.
No, this is NEET
Entrance.
UG examination. I'm seeking revaluation of the answer sheet. My lord, from the counter affidavit.
Counter affidavit is not there on the court. It's there. Reply affidavit.
My lord, kindly see page 19, calculation sheet. In respect of question number 148, it has been evaluated as a wrong answer and 5 marks has been deducted. My lord, kindly see page 18.
Page 18.
18.
Yes.
Where in respect of question number 148, I have not given any answer, not responded. But there is a stray mark how it and it was calculated as a wrong answer. And thereafter, although I have attempted question number 149, which is correct answer.
We have messed up everything, 148.
148, there is some mark over there. What have you done?
No, that mark has not, many candidate is required to bubble the space.
Oh, he can scribe, he can.
No, I have not scribed. If the original is called for, then it can be ascertained
What
whether.
is that mark there?
My lord, I think it was.
That your thinking will not apply.
No, I have not.
No, is there is no.
This is apparent.
What is that exactly?
This is apparent, and why will they?
No.
Original.
Okay, one is 148, the other one is?
Other 149 I have answered. It was a correct answer. That was not taken into account.
First one, okay.
149 has not been taken into account.
I have made correct answer. That was not taken into account.
This is their document.
My lord, it is their document. I pray if the original answer sheet is called for, then it will be clear.
It is looks as if 148, 2 has been marked and then dropped off. 148, what is the correct answer?
My lord, 148 correct answer is 3.
Can't be 2. Huh?
3. But it was taken, I have as if I have answered 2.
It looks like that. A mess
My
has
lord.
been created.
And
over
149,
Okay, 149, okay.
it was not calculated.
148.
As first 10 questions will be calculated. My prayer is if the answer sheet is called for, then it will be clear whether I have attempted or not.
See, how many candidates appear
30, more than 30 lakh.
and how many fail? We start doing this.
No, my lord, I have
Every case.
my mark is 639. There is, if 4 marks is given, I will get MBBS seat in a medical college.
So for 149, will you get 4 marks?
No, 4 marks if will be awarded, I will be 6.
That is what I'm asking. For 149, how many marks will you get?
No, I got 639. They have given me 639. If this is wrong and 149 will be calculated, I will get 644. And there is a chance.
What is the marks?
I got 639 marks. They have calculated.
So how much will you get if 149 is found to be correct?
I will 5 marks will be awarded. My mark will be 644.
So each question
carries 4 marks. But if one question wrong, then 1 mark will be deducted out of the total mark.
Irrespective of 148, whether you have attempted or not, if we just consider 149, then you'll get 5 more marks.
5 more marks.
So let us forget about 148.
No, I have made 163 correct answers. And 13, they are saying 13 wrong answers. As a result, I have been awarded 639 marks. But if question number 148 is not calculated and 149 is calculated, I will get 5 marks more.
149 will have to be calculated. That marks will have to be deducted.
My lord, they have not calculated. First 10 questions.
148. What about 149, Mr. Palli?
No, our role is very limited. We don't have anything to do with this
You
mark
have
sheet.
not seen the counter.
No, counter has not been served.
Show
It has
him.
been,
Let him have a look.
Who is appealing for
for
NTA?
this NTA probably.
NTS is
Central government.
Central government.
Central government, NEET.
Who
Central
is
government.
there? Did you inform him?
Probably Mr. Padi.
No, my lord, I have not.
What can be done?
Mr. Padi probably. Mr. Padi, DSG.
Satpati, some Satpati has signed. Tomorrow.
Applied till today. Promotion matter, let's see.
Give me a slip.
Maybe fix it 30.
Give me a slip. Give you.
Yes, admission item number 1.
Item number 1, Your Lordship, it's a matter related to 29 extension of the mandate of the Arbiter. Your Lordship, I'll examine the point of law. Let it come 2 weeks after, Your Lordship.
No, 29, that has been decided finally.
Your Lordship, as far as we have filed it, I'll examine the point of law. Your Lordship.
What?
Exactly whether it has to be filed here or in the before your.
That has been decided by Supreme Court. Where is the question of examination, further examination?
I'll go through that judgment, Your Lordship. Just give me a 1 week time, Your Lordship.
As requested on behalf of the petitioner, this matter on next Wednesday.
Item number 2.
So grateful.
Number 2 is number 3.
Arbitration clause is at page 19, Your Lordship. Clause 20.
Yes.
Subsequently, notice was issued on 5th July 2023, Your Lordship. 2023, Your Lordship. The reply has been given on 16th August 23, Your Lordship.
You so notice.
Item number 3.
Please, Lordship. Yes.
Page 195 is the dispute.
Yes.
So I'll accept it.
Is this matter on 2 weeks?
Yes, ma'am.
So as to an appellant counsel for the opposite party or respondent?
Opposite party.
Opposite party. Seek instructions and file affidavit.
Item 4.
Please, Your Lordship. The arbitration clause, my lords, is a page, starts from page 37. The arbitration clause, my lords, starts from page 37.
Item number
4.
4.
It has been taken up for the first time.
First time.
Okay.
Item 5.
5, Your Lordship. On last occasion, Your Lordship had directed both of us to find out with regard to the appointment, since we are seeking appointment of a third arbitrator, presiding arbitrator, Your Lordship may recollect. My learned friend has shared me a list. I had also shared a list with him. I think it's a case of deadlock because I've given my list.
All right.
What I've seen from his list is that my learned friend is seeking an appointment from local appointment. But then since one of the already appointed arbitrators is a retired judge of this honorable court, so I am seeking on the basis of seniority.
All my list, Your Lordship, all are the senior to Justice B.N. Rathan. Because dispute is within
with schedule 4 in place, there should not be any concern regarding the fee structure is already there under schedule 4. So there should not be any concern with regard to local or anywhere else.
No. The reason is different. The reason is that someone will have to come from Delhi to Odisha, or someone will have to go from Odisha to Delhi. That is the.
For that purpose, I have given 2 names. I've given Honorable Justice, retired Justice Prasad's name and Anand Patnaik, who are very senior.
What difficulty do you have with Justice E.K. Patnaik?
I have no difficulty, Miller.
Then
But
talk to him.
But Lordship, because saying that he's perhaps he's staying in Delhi. That's
Whether if he agrees, then so.
Your Lordship,
Huh?
on the consent of the party.
Justice E.K. Patnaik? This is item number
5.
5 pillars.
36 of 2024.
Yes.
Huh?
Yes. Last order.
No, but please come to paragraph 1. What have you? Your petition.
Lordship.
Paragraph 1 of your petition.
Yes. Yes, Lords. Paragraph 1.
Paragraph 1, that is incorrect, I think.
Yes.
Prayer, Your Lords.
The wording is incorrect.
Prayer.
So this is under 11.4b.
It is under 11.4b, presiding. Because yes, Lord, this is application under section 11.4b.
Though incorrectly though provision of law has incorrectly been mentioned at the top for appointment of an arbitrator, it is an admitted, it is manifest that this is an application for appointment of
Presiding arbitrator.
presiding of arbitrator under clause B of subsection 4 of section 11 of the Arbitration and Conciliation Act, 1996. Stop. Who has been appointed?
The petitioner appointed a former judge of this Honorable Court, that is Justice Biswanath Rath.
Mr. Justice Viswanath Rath has been appointed as one of the 3 arbitrators at the instance of the petitioner, whereas Dr. A.K. Rath, Dr. Justice
Samir Kumar Jain.
Mr. Samir Kumar Jain.
Yes.
Appointed by them, my lord.
Whereas Mr. Samir Kumar Jain has been appointed as the second arbitrator at the instance of the respondent. Stop. The 2 arbitrators have failed to agree on the 3rd arbitrator.
Failed to appoint.
Failed to agree. 3rd arbitrator for appointment as the presiding arbitrator. So stop. Next. After having considered submissions made on behalf of the parties, Mr. Justice Anang Kumar Patnaik, a former judge of Supreme Court of India, so is hereby appointed as the presiding arbitrator. This application stands disposed of.
Deeply obliged.
Item number 6.
Lord, the arbitration clause is at page 60. So transaction of purchase of
It
court.
has been listed for the first time.
Yes, ma'am.
All right. Notice.
Item 7.
Obliged.
Item number 7. This is
Item number 7.
Actually, this matter is, yes, this is Saurabh Sagar Behra for item number 7. Sir, actually, this matter is related to some dispute related to notice period, which arose while I was working in some private organization, Ottawa, from 12th of November 2020 to 30th of November 2021. So this dispute is related to notice period. Even if I'm carrying the written admission of the organization, it is 3-month notice period both sides. But they have blocked my 3 months salary and they are not providing.
Where is the agreement?
Agreement is 1 second, my lord. Kindly. Kindly move on to page number 9.
Page number 9.
Yes, sir. Yes, my lord. Page number 9.
Where is the arbitration agreement?
Agreement, actually, I received over the email offer letter.
Mr.
Offer letter
Counsel, where is the
offer letter,
arbitration agreement? Is there any arbitration agreement?
Agreement, yes, that is the offer letter actually we signed from both sides.
Do you understand the difference
page
between
number
agreement and arbitration agreement? Do you understand the
Sir, it
difference
is,
between? Was there any arbitration clause in your appointment letter?
There is one appointment letter and one offer letter, sir.
The present application has been filed for appointment of an arbitrator under section 11(5) of the Arbitration Conciliation Act 1996. Of this application, in the court's opinion, is misconceived for the reason that no arbitration agreement appears to be in. There is no agreement between the parties to the effect that dispute, if any, shall be resolved through the process of arbitration under the provisions of Arbitration and Conciliation Act 1996. So this application is accordingly dismissed. Yes.
Item number 8.
Item number 8, my lords, permitted to withdraw.
Item 8.
Item number 8, my lords, I'm on VC. Permitted to withdraw, my lords.
Withdraw.
Obliged.
Item number 9.
Item number 9, the arbitration clause is at page 42.
It has been listed for the first time.
First time, Your Lordship.
Where is that arbitration agreement?
Page 42, clause 6.
Page
42.
Yes. You have followed the procedure prescribed. Notices were issued.
Yes, Your Lordship. Notice has been issued.
Yes.
Much obliged.
Item number 10.
May I prefer an adjournment just 1 week?
Right. All right. As a question from you.
Item 11.
Fresh matter, madam. The arbitration agreement is at page 43. It comes for the first time. Page 43, article 13.
Just where is that?
All the matters are similar matters.
Oh, just let me see the. Which page is that?
43 minutes, 43.
Yes.
Article 13. It's a batch of matters, my lord. All of them are different. Similar agreements. Wait for me.
Separate orders.
Item 12.
So if I may please your lordship, my lord, the arbitration agreement is at page 45. The notice for arbitration is at page 62. The reply notice is at page 66. It has come up for the first time, your lordship. Notice is
Yes, sure. Okay.
grateful.
Item number 13.
Yes.
Item 13.
I'm sorry, my pleasure. Lordship, the appellant is petitioner is praying for appointment of
Where is
arbitrator.
the arbitration agreement?
That is your lordship at page That is page 57. Sorry, page 50, Your Lordship, 50.
Page 50.
Yes, Your Lordship. Annexure 7, page 45, and the running page is
Page 45.
45.
Where is the arbitration agreement?
There is no such any arbitration agreement, but the agreement between the parties under Annexure 1, Your Lordship.
Sorry.
So, may I pray, Your Lordship, kindly consider Your Lordship appointment and agreement.
That
Because of
cannot
Your
be
Lordship, for a moment, kindly see the page 50, Your Lordship.
We have seen.
Yes, Your Lordship.
I've seen that. But unless there is arbitration agreement, that cannot be done. This application has been filed for appointment of an arbitrator under the provisions of Section 11 of the Arbitration and Conciliation Act. Stop. From the submission advanced on behalf of the petitioner, it appears that there is no.
May I permit Your Lordship permit to withdraw and approach before the
counsel for
commercial.
the petitioner after the argument seeks permission to withdraw this application. It's a liberty to take recourse to appropriate provision of law.
Approaching before the commercial court.
Appropriate forum?
Yes.
Appropriate forum for resolution of the dispute between the petitioner and the respondent. Yes.
Item number 14.
But if I may please your lordship, my lord, the arbitration agreement is at page 18.
Yes.
The notice for arbitration is at page 28.
You should notice.
Gratefully, lordship.
For orders item 15.
May I please proceed? My lord, by order dated 1st March 2024, my lord was pleased to appoint arbitrator.
Mr. The question is
My lord.
whether this court
My lord.
once had appointed an arbitrator,
My lord.
it becomes functus officio.
My lord. After recusal of the learned arbitrator.
Yes.
Yes, my lord.
So can the court appoint?
My lord. Under
Because
section 11.
I did some research. There is a judgment of the Allahabad High Court on exactly this point, my lord. Lordship, may I have paragraph 2. The arbitration clause provides for a named arbitrator. The named arbitrators failed to perform their functions entrusted to them under the arbitration clause. Accordingly, an application was filed by the applicant herein under section 11(6) of the Act, whereupon this court issued notice to the respondents herein, and thereafter video order dated this appointed justice as an arbitrator in the matter. As luck would have it, justice left for his heavenly abode while he was proceeding with the arbitration. In these circumstances, the applicant has filed this application for appointment of a substitute arbitrator in terms of section 15(2) of the Act of 1996. Shri Jaspreet Singh, learned counsel appearing for the respondent, raised an objection that the application is not maintainable as the conditions mentioned in subsection 3 and 4 of section 11 are not satisfied, and also as the eventualities mentioned in clause A, B, and C of subsection 6 are not satisfied. Then your lordship may kindly have paragraph 9.
Yes.
Lordship has paragraph 9.
Yes.
The fact that section 15 is attracted in the present case is not in dispute. The dispute raised by Shri Jaspreet Singh is as to whether for appointment of a substitute arbitrator under section 15(2), an application would lie straightaway before this court under section 11(6), read with the aforesaid provision, or as contended by him, the applicant would have to first approach the respondent for appointment of an arbitrator, thereafter on any of the eventualities mentioned in clause A, B, and C of subsection 6 of section 11 alone. Such an application would be maintainable before the court and not prior to it. Lordship, paragraph 11 is the reasoning given by the court, and the final finding is at paragraph 22.
But have you seen the recent decision of court? Recent. Justice. Oh. Do you remember that decision, Mr. Mahanti? That the Supreme Court's decision by Justice. Oh.
The latest one, your lordship, against Manipur High Court.
Yes,
is-
Meghalaya.
Manad on 29 name, Manad.
Yes.
I have the. It is Chief Engineer NHPWD Roads versus Messrs BSc and CNC JV. Order dated 13/5/2024. Manad.
Which provision you're relying on?
My lord, under section 11(6), appointment of arbitrator has already been made by this honorable court. And accordingly, after recusal of the learned arbitrator, now, as per the rule, the arbitrator can be appointed by this honorable court. Your lordship is vested with the power for appointment of arbitrator under section 11, subsection 6 of the Arbitration Concealment Act, because section 15(2) is attracted since the learned arbitrator appointed by my lord has been recused from
11(6).
Under section 15(2), he has
15(2).
My lord, I have also brought a decision of the Honorable Supreme Court in this regard.
Just. So mandate of an arbitrator terminates in the circumstances mentioned in section 15.
14,
Section
yes.
15.
My lord, regarding failure or impossibility to act, that is under section provided under section 14, and the termination of mandate and substitution of arbitrator is stipulated under section 15 of the Arbitration Constitution Act 1996. Because recusal is recusal means withdrawal
13,
from the
14 and 15.
My lord.
These are three provisions
My lord.
under which the mandate of an arbitrator terminates.
My lord.
And then 29A also provides for termination of the mandate.
My lord.
Huh?
29 is considered.
See, therefore, it's a matter which requires consideration.
My lord.
Section 13, Section 14, and Section 15 deal with the circumstances in which the mandate of an arbitrator shall terminate.
My lord.
All right. Section 29A also uses the same thing.
Beyond the period of the 1.5 years.
The mandate of arbitrators shall terminate. All right. And then it provides for
Application
appointment
for
of-
extension and
before the court. So the difference between section 15 and section 29A is that section 29
your lordships have held that 29A, if it is appointed under 11(6), will be done by the Honorable High Court.
No.
Supreme Court has said otherwise.
Supreme Court has said otherwise, and we
The
have
court is
followed
principal civil court.
principal civil court because court is mentioned in section 29A.
And 2(1)E defines court. 2(1)E. Now the problem is that now this Honorable Supreme Court has decided the court will be the commercial court, where there is a commercial court.
All right. Do you have any name?
My lord. Justice Pramod Patel.
I have no objection.
Then you will have to make a fresh application. I will not do. You will have to make a fresh application, not on the basis of
Okay,
this.
even the Allahabad judgment contemplates a fresh application.
Yes, you will have to make a fresh application, not in disposal of application.
Previously, as per procedural practice was going on.
No precedence. No, you will have to make an application. That application was under
Sure.
Rule 5. Make an application, don't worry, we will expedite your case.
Yes, my lord. I may permit to
Learn counsel for. the
file another fresh
petitioner.
application with liberty. Though I have already
Submits
filed
that
application
he
under
will
section
not
11(6)
press IA number 20 of 2024. But seeks liberty to file fresh application for appointment of an arbitrator as the learned arbitrator who was appointed under section 11(6) of the Act has withdrawn to act as an arbitrator.
It may be converted into under section.
That cannot. Why are you in so much of a hurry?
My lord.
Yes.
For admission item.
Stands dismissed as not placed, the liberty as sought.
My lord, let's.
Item number 16.
Yeah, please, Lordship. Similar matter matters to the previous one, matters, 15 substitute arbitrator matters. I've
Have you
already
filed a fresh application?
fresh, I've already sent notice matters. I filed matter, Annex 6, page 69 matters. And for on section 15(2) for substitute arbitrator, they have to they have not replied to anything like that. My lords had the power to appoint matters.
So this is an application under 15(2).
15(2) and along with 11(6). Along with 11(6), 15(2), my lords.
Yes, yes.
15(2) I've sent a notice already. They've not replied to that. And that's why I approached my lords.
In fact, your lordship had directed me to examine this issue on the last occasion. Because I found a judgment of the Supreme Court, your lordship, 2006.
I've also a judgment of Supreme Court matter 2016 direct to this point matters whether we would decide matters.
Lords, if your lordship may take the second page of the judgment, lords. Paragraph 4, your lordship, the facts and the case has been summarized there, my lords. Here, your lordship, the case is that, my lords, after appointment, there was withdrawal by the arbitrator. And my lords, the Supreme Court held that a fresh notice has to be issued as per the rules. And here the rules would mean the terms and conditions of the agreement itself, not the statutory rules, my lords. So therefore, they have to send a fresh notice in this case, which they have done, my lords, that they have annexed, and we have replied to that notice also. My lords. Lordship may appoint the arbitrator. Only, my lords, the question of limitation and other questions may only be left open for the arbitrator to decide, your lordships.
What is the question of limitation?
My lords, because they have
All the questions are open for the arbitrator.
lordship, it's open. If it's open, my lords, lordship may just observe that for my convenience.
Here already the claim statements has been filed. They have appeared. Anyway, that will be left open, my lords. I propose, my lords, justice.
Claims had been filed before the previous arbitrator.
Yes, my lords. And I suggest
What are
name
the
of
facts?
Justice B.K. Naik, Honorable Retired Judge of this High Court. I've already taken, discussed with him.
I have no objection, your lordship.
Should I adjourn the matter for the next week? So that I'll be passing a detailed order that I shall be following other cases also similar. Because all these things sometimes we. Or I can dictate.
This is directly covered, my lords.
No,
2016 Supreme Court, which
just give me the.
I've given it, my lords. I've given the judgment, my lords.
No, judgment is there, but the dates.
Citation, my lords.
The dates, relevant dates.
My lords.
Dates.
My lords. That is the agreement, my lords. The agreement is annexure 1, page 10 to 63. 1/11/2011, my lords. The copy of the letter dated 5/2/2020, the mutual appointment of sole arbitrator is a mutually agreed appointment. 5/2/2020, my lords.
Yeah.
Then, my lords, 19/2/2020. 20, my lords. Advocate to sole arbitrator of this kind. Advocate to sole arbitrator for his kind consent. Consent was given, my lords. Earlier, my lords. 29/2/2020. The consent was given, sent by both the parties, my lords. The copy of the consent letter, that is 13/5/2020. Copy of the consent letter of the sole arbitrator. He has given the consent.
Where is the appointment, earlier appointment?
Earlier appointment is Annex 3, my lords, page 65. Copy of the letter dated 20 for petitioner advocate to sole arbitrator for his kind consent. He has given the consent. Annex 3, my lords. That is letter 5/2/2000, the mutual appointment of sole arbitrator. Appointment. I given earlier, my lords. 5/2/2020. That is appointment of sole arbitrator, my lords.
Yes.
My lords. Then the withdrawal, my lords, by the sole arbitrator, that is 11/3.
What is the date of Annex 3?
Annex 3 is 29/2/2020.
Right. Then?
My lords. Then the withdrawal, my lords, by the sole arbitrators, that is 11/3/2022, my lords. Then, my lords, 24/3/2022, that is the fresh notice of appointment under section 15(2) to the authorities. These are the important dates, my lords.
Yes.
My lords. And the judgment, my lords, the Supreme Court has given 2016, I have already submitted. Directly covering this case, my lords. And my lords has the ample power to appoint, my lords.
There was an agreement between the petitioners and Odisha State Disaster Management.
Odisha State Disaster Management
State Disaster
OSDMA.
Management Authority executed on 1/11/2011. Which is the arbitration clause?
This 54.
Clause of which contains arbitration clause for a resolution of any dispute arising out of the said agreement. So,
25.3.
it is not disputed that a sole arbitrator was appointed with the consent of the parties on 29/2/2020. Is it correct?
Malice. No, that is copy of the letter 5/2/2020. 5/2.
5/2/2020.
Malice. That is at Annex 2.
5/2/2020. Sole arbitrator, Mr. So-and-so. What is his name? Name of the
L. Pongari. Just Mr. L. Pongari, senior advocate. Lakshmidhar Pongari.
Okay. Later, where is the withdrawal?
Withdrawal is at page 67, my lords. Page, copy of the withdrawal. 67. 11/3/22.
Annexure?
Annexures 5, my lords.
Later, the then sole arbitrator withdrew himself from the office of the arbitrator as arbitrator as recorded in order number 5 dated 11/3/2022, vacated annexure 5. Stop. Consequent upon withdrawal of Mr. So and so from the office of the arbitrator, comma, the petitioner put the respondent on notice for appointment of a substitute arbitrator. Stop. As no arbitrator could be appointed, no substitute arbitrator could be appointed by the parties, comma, present application has been filed under section 15 bracketed 2 read with select section 11 of the Arbitration and Conciliation Act for appointment of a substitute arbitrator. Stop. Next. Section 14 of the Act prescribes inter alia that the mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator if he withdraws from his office or the parties agree to termination of his mandate. So stop. Section 15 of the Act deals with termination of mandate and substitution of arbitrator and reads as under. So stop. Subsection 2. Highlight. It is with reference to subsection 2 of section 15 of the Arbitration and Conciliation Act that this application has been filed by the petitioner for appointment of a substitute arbitrator. Stop. Learned counsel appearing on behalf of the petitioner with reference to subsection 2 of section 15 has submitted that a substitute arbitrator, comma, in the given circumstance, comma, is required to be appointed in accordance with the rules / law applicable to the appointment of arbitrator being replaced. So stop. He has submitted that following the provisions of the Act, the petitioner had put the respondent on notice for appointment of an arbitrator, and as the parties failed to appoint an arbitrator, substitute arbitrator, this application filed under section 15 bracketed 2, 15 bracketed 2 read with section 11 of the Arbitration and Conciliation Act is maintainable. So stop. Next he has placed reliance on a Supreme Court's decision in case of Sailesh Dharyava versus Mohan Balakrishna Lalla,
2016, 3 Supreme Court,
reported
619.
in 2016,
3.
16 volume 3 SCC, page
619 months.
619. Please give.
Months.
Which paragraph?
19 and 20 is the relevant. Even the placitum I have marked, my lord, that also is there.
19.
Placitum, the green. Also 19 and 20, my lord, that's the relevant paragraphs. And 20, even the last one, that is 35, paragraph 35 also. 19, 20 and 35.
Stop. Learned counsel appearing on behalf of the respondent has not disputed this legal position and has assisted this court by referring to another Supreme Court decision in case of Yaswith Constructions Private Limited versus Simplex Concrete Tiles India Limited, reported in 2006, volume 6 SCC 204. Stop. Next, after having perused the contents of the application and materials on record and examined the law laid down by the Supreme Court in case of Yaswith Construction bracketed Supra, the Supreme Court has held in paragraph that the withdrawal of an arbitrator from the office for any reason is within the purview of section 15 bracketed 1 bracketed A of the Act, and therefore section 15 bracketed 2 would be attracted and a substitute arbitrator has to be appointed according to the rules that are applicable for the appointment of arbitrator to be replaced. To stop. Clarifying further, the Supreme Court has held that what section 15 bracketed 2 contemplates is an appointment of substitute arbitrator or a replacing of arbitrator by another according to the rules single inverted, rules that were applicable to the appointment of the original arbitrator who was being replaced. So stop. The term rules in section 15 bracketed 2, comma, the Supreme Court has held, comma, refers to the provision for appointment contained in the arbitration agreement or any rules of any institution under which the disputes were referred to arbitration. So stop. In case of Sales Dharava bracketed supra, the Supreme Court speaking through Justice Nariman J has held that in paragraphs 19 to 21 as under. So stop. Next, supplementing the view formed by Justice Nariman J. Nariman J, comma, Dr. Justice Sikri J in case of Salis Dharyava, no, but that is 29 is not relevant.
Well, that's not relevant here. Not relevant.
The said view. After having gone through the averments made in the application, comma, examined the statutory provisions and the law laid down by the Supreme Court in case of so and so, comma, I am satisfied that in a case where an arbitrator, mandate of an arbitrator stands terminated because of his withdrawal from his office, comma, this court has jurisdiction to appoint a substitute arbitrator in accordance with the provision under section 15 bracketed 2 read with section 11 of the Arbitration Conciliation Act, Arbitration Act, if the parties fail to appoint an arbitrator. On an application made by a party after satisfying the requirements of appointment of arbitrator under the provisions of section 11 of the Act. Also, and counsel appearing on behalf of the parties have consented to the name of
Justice B.K. Naik, Honorable
Justice
Retired Justice.
B.K. Naik, a retired judge of this court, to be appointed as substitute arbitrator. So stop accordingly. Yes.
Deeply obliged. Arbitration center news.
Yes. What happened?
Deeply affected.
He is suggesting something.
I was listening to your lordship, AFR this order so that we.
No.
We are laying down a law.
No, we are just following. Yes, sometimes we mention AFR, but most of the judgments are unnecessarily mentioned that.
Lords, may I make a small prayer, Your Lordship? Lords, my name may kindly be reflected. Lords.
Yes, sir. Your name,
Shaunak Mishra.
your submission is also there.
Lordship.
Item number 17.
Petitioner has to submit a English translated copy of Annex 1 and 2. And I pray 2 weeks time to file a.
Your application cannot be maintained. This item, you did not file the agreement.
Agreement is there, Annex 1,
17.
arbitration clause, clause 12. But due to some difficulties of the petitioner's counsel, some of the relative expired. So I pray.
Mr. This application was filed in 2023.
For the last chance,
Where is the question of last chance?
Last chance.
No, your application cannot be entertained.
Arbitration clause is there.
Where is that?
Page 24.
Page 24.
That is in Odia. So,
no problem. Where is that? I will not read, but I will at least understand that there is something. Where is that?
Page 24, clause 12. Nispati jodi bhavishyatre ukta chukti patra.
Just a minute. Page 24.
Well,
what is this?
If there is some dispute and if there is dispute between the parties, that the matter may be referred to arbitrator.
Arbitrator under the Arbitration Conciliation Act.
Well,
sorry. Yes, who is for the other side? File an English translation. I'll see. What is this? But read it. What is the meaning of this? What is the meaning of this?
in future, as per this agreement and construction of the house, if there is some dispute or misunderstanding, then the second party will appoint a arbitrator to solve the problem, and to his decision both party will obey and abide.
Who is the other party?
Page 20.
And where is the development agreement?
Development agreement is page 12 to 26.
12 to 26.
Ma'am.
And the agreement was between you and?
And the second, that is erstwhile, that the opposite party, erstwhile infrastructure private limited.
Infrastructure Private Limited. So that company is surviving or not?
This notice has been issued.
Hmm? Oh, its name is erstwhile infrastructure. Wonderful.
Represented through its managing director, Sri Jairam Misra.
And what about service of notice?
Notice has been sent.
Yes. No one is
The
appearing.
order, my lord, order dated 19/7/2024.
No, that we are seeing. I am seeing that.
Well, the matter is taken. The notice is said to have been validly served upon the opposite party. No one has entered appearance on behalf of the opposite party.
Despite valid
List
service
is-
of notice upon opposite party number on the opposite party, there is no representation on his behalf. So list this matter on next week. And the court will next week. An English translation of the agreement be filed on behalf of the petitioner in the meanwhile. File it.
Item number 18.
Actually, this is a very small amount matters, around 9 lakhs. We are actually thinking of, I think a settlement will be better than going through. We've spoken to our client, we'll communicate to them. Let us at least take recourse to that. If it works out well and good. It's a very small claim of 9 lakhs.
And what is the what is the eligibility of an arbitrator?
No, it's just a simple arbitration clause.
Therefore, some young lawyer can be appointed.
Yes, but we still want to venture that. We want to see a recourse before. Really
No, this is how you can train young lawyers also to become arbitrators.
Absolutely. In fact, ultimately that happens, I will have to go for a young lawyer also.
Someone sitting today in the courtroom, youngest amongst them.
Maybe we'll take that chance if you'll also gives us one more day.
All right.
I am the youngest of the lot sitting.
No, there are people.
But you can't.
I can't.
Because
But
you're
yeah,
the opposite side.
There are lawyers. I can see a very young female lawyer in the 4th row or 3rd row, and yes.
Definitely, lots of will consider.
But if the eligibility, they fulfill the eligibility criteria, then you can start with this
We'll
amount.
examine that because one of the parties is Odisha Mining Corporation, so we'll examine that. Okay, but we'll get back on that point.
As requested on
No, but we
behalf
have many competent young lawyers, so that's not an issue for our part.
My lord, my learned senior, Mr.
No, but that is the court's discretion. That is the court's discretion to appoint.
Yes, sir.
There are many lawyers, so out of them,
I agree with your
All
lordship's
right.
viewpoint. That's what I was trying to
All right.
express.
As requested on behalf of the petitioner, list this matter on 1 week,
My lord.
2 weeks.
2
All
weeks.
right, 2 weeks.
Item 19.
Yes.
Item 19, my lords. Notice to opposite part number 1, the company has made subset. But opposite part number 2, my lords require directed the registry to get the tracking report. The noting is that the tracking report is not available, is not made available.
So who is opposite party number 2?
Opposite part number 2 under whom I was working. Opposite part number 1 is the authority, my lords, managing director of the company. Opposite part number 2 is a subordinate officer to the opposite part number 1, managing director, under whom I was working.
No, the agreement was between you and whom?
But the work order was issued by opposite part number 2 on behalf of opposite part number 1.
No, but where is the agreement, arbitration agreement?
Arbitration clause, my lord, kindly have a glance to page 14, clause number 7.
Page 14.
14, my lord.
Which clause?
Last clause number 7, arbitration clause.
17.
17, ma'am. Sorry, my lord, my part is not in the photocopy, my lord, it is not come. In the event of any dispute or differences arising out. The subparagraph. Maybe also.
Sir, is there a public sector undertaking?
No. Also, it's a private company.
Despite notice have been served? Despite service of notice upon the concerned opposite party number 1, there is no representation on its behalf, lest this case for admission. Yes.
Item 20.
If I may please the lordship, my lord, I am appearing for the petitioner. My lord, there are talks of settlement going on with the opposite party. I have instructions and so it is possible that the settlement might happen.
Why are you keeping this arbitration matter pending?
My lord, 2 weeks, just in case there is no settlement.
On behalf of the counsel appearing on behalf of the petitioner states that the parties are making sincere endeavor to resolve the dispute. So he seeks adjournment on the said ground, lists this matter on 2 weeks.
Item 21.
Gratefully, lordship.
My lords, the arbitration agreement under annexure 1 clause is at page 14, my lord. Clause 11. Sorry, my lord. Page 15, clause 15.
This has come for orders. Why? This is for admission.
Yes, my lord.
Fresh admission.
No, notice was issued, my lord.
Notice was issued. Who is appearing for the other side?
My lord, I am for the opinion number 2.
My lord, I am for the opinion number 1, my lord.
Yes, dispute is between you and?
My and opinion number 1, my lord.
And why are you there?
Opinion number 2, he is another brother.
I am one of the partners, my lord.
Partner.
My lord, dispute between the 3 brothers, my lord, regarding some animal as per one agreement that was in the regarding some film production and company, my lord.
Where is the agreement?
At page 15, clause 15.
Page?
Page 15, clause 15.
Yes. So how many arbitrators?
Not specific, but one. One arbitrator.
No, it's.
No, my lord.
It has not been specified there.
No, my lord, as per that agreement, it is supposed to be a 3 arbitrator, my lord. Only what is like this, my lord, in case of the dispute or difference opinion between the parties, each partner shall select arbitrators and the matter shall be referred to the arbitrators. Those selected and their decision shall be final and binding on the partners. In case the arbitration do not come to any decision, they shall refer the matter to an umpire to be selected by the arbitrator, my lord. This is the language. And my lord, for my instruction, my lord, that this agreement has not been already been that is not in existence, my lord. Not in existence. All things have been over. And my lord, the property who
Arbitration clause will survive.
is my lord. But my lord, my
All
lord,
the arbitration, all terms might have expired, but arbitration clause has survived for the purpose of redressal. This is one aspect. The other aspect is how can the arbitrators be appointed in view of the nature of the agreement? See, the decision according to you shall be referred to an umpire to be selected by the arbitrators. So this is not contemplated under the arbitration conciliation.
Earlier, the dispute between the parties were referred to Arbitration Honorable Justice S.C. Paria, my lord. Thereafter, when the matter was pending before Honorable Justice Paria as arbitrator, my lord, the parties entered into this agreement. And this agreement was filed before the arbitrator. And therefore the matter settled down. And pursuant to this agreement, my lord, the OP number 1 violated the terms and conditions. Accordingly, I issued notice, didn't respond. Therefore, lawyer's notice at annexure, my lord, to annexure, that is, my lord, annexure 6 at page.
This arbitration clause is not in consonance with the provisions of the Arbitration Conciliation Act.
My lord. One thing,
So you can get your dispute resolved outside, or we can file not through arbitration. So what do you want?
One thing I suggest, my lord, because when the opposite party number is not responding, I am suggesting one name subject to acceptance of my lords. If my lord and will agree, then matter will.
How can I do? I am of the prima facie view that this cannot be treated as an arbitration agreement between the rather under the provisions of the Act.
As per the terms, clause 15, it says that in case of any dispute or differences of opinion between the partners, each partner shall select arbitrators, and the matter shall be referred to the arbitrators, thus selected, and the decision shall be final and binding on all the partners. In case the arbitrators do not come to any decision, they shall refer the matter to an umpire to be selected by the arbitrators, and on that case,
This is under which provision? Under which provision the matter shall be referred to an umpire?
We had issued, the petitioner issued a notice, but he did not turn up for appointment of an arbitrator. That is the reason the petitioner approached this honorable court.
So whether this application is maintainable or not according to you?
Well, on the consent of the parties, your lordship will
Consent
kindly
of the parties, we cannot change law.
appoint. The
Consent
arbitration
of the
clause
parties,
is
we can follow
admittedly
law.
there.
Examine, I am not satisfied.
In case of failure, then the material, the clause is in the material.
See, if the matter is referred to our tribunal, arbitration tribunal, under the provisions of clause 15, then that will decide, the arbitration tribunal will decide.
My lord.
And thereafter, if someone is aggrieved by the decision of the tribunal, then that can be challenged under section 34.
My lord.
It's not that that will be referred to an umpire to be appointed by you.
No,
So this process, this procedure is not contemplated under the Act. If today I appoint arbitrators, then according to you, the arbitrators will be challenged before the umpire.
Now, if the decision of the arbitrators will not, that is, if the decision which will be given by the arbitrator, then they may refer the matter to that.
Difficult. We'll examine next week. I'll see. In the meanwhile, you also decide what you want to do. I have disclosed my mind.
Item 22.
Next week, let you lot call it next week.
Next week.
My lord.
Yeah, please, your lordship. The arbitration clause is there.
In arbitration is to be appointed.
Yes.
Not fight and counter, what we are suggesting is the agreeable Justice S. Mundidhar may be appointed.
My lord, Mahip, Justice C.R. Das may be of this honorable court.
Then we prefer
C.R.
Justice
Das.
Vijit Mahathi in that case.
Vijit Mahathi.
My lord.
Ask your client if he is here. The client is here.
My lord, I was asking my instructing counsel. So,
Okay.
JP Das, if it's JP Das,
We've
Justice
already taken
Honorable Justice.
instruction. This is a PSU, your lordship. We've already taken an instruction from this matter.
All right.
We are
Just,
only asking
my lord
Justice.
Justice JP Das is also retired judge of this honorable court.
Keep on. All right.
Ma.
Item number 23.
His name is Mr. BP Mohanty or B Mohanty?
No, we suggested.
JP Das, JP Das.
No, I have recorded his name.
JP Das.
Mr. Mohanty.
This is my.
Name is there.
My lord,
Yes,
JP
his
Das,
name is-
JP Das name is also there because my lord.
Item number 23.
This is an application for appointment of arbitrator. In this matter, 2 times we have issued notice to the opposite parties. And despite valid service of notice to opposite party number 1, that is a head office of the Mahindra and Mahindra Financial Services Limited, no one has appeared on the last occasion this time. So my humble submission is to appoint any retired district judge to adjudicate the dispute between 2 parties. Or anyone from the panel.
What is the amount?
11,56,401.
No, but you want substitution, you want change.
Sir, in this matter, all the cause of action have arrived in Dhenkanal district of Odisha. The opposite parties have issued a notice suggesting 5 advocates, name of 5 advocates for an arbitrator.
No, whether any arbitrator was appointed earlier or not.
No, Your Honor. They have just gave a notice to us for the process of
Mr.
arbitration in
Vijay
Maharashtra.
Kumar Gandhi was appointed arbitrator.
No, the petitioner doesn't give any consent to that, sir. We have also replied to that. That is on Annexure 3. And they have not responded to that, sir. They have only gave the name suggestions of advocates.
Where is that? Arbitration.
Page
agreement?
number 14, Annexure 2. And the petitioner reply is in Annexure 3, page number 16.
Where is the arbitration agreement?
Sorry.
Where is the arbitration agreement?
So they are not providing to us. We have repeatedly told them.
You don't have the arbitration agreement.
They are not supplying to us. At
Then
the
you
time,
cannot maintain this application. This application. The agreement.
we have asked them
The
severally.
arbitration agreement has not been brought on record. So in such view of the matter, this application for appointment of arbitrator, the section so and so cannot be entertained, is dismissed accordingly. Yes.
Item 24.
Yes, no one appears on behalf of the petitioner. What is this matter next week?
Item 25.
Minutes on consent. The parties I am appearing on behalf of the petitioner. My lords, here application for appointment of arbitrator. The arbitration clause is at page 38.
Is there any dispute?
Well, I had raised an argument of limitation on the last occasion. However, that my argument will not survive in light of the Supreme Court COVID-19 orders, because a large portion of the period is covered by the COVID-19. If your lordship may.
Yes.
Your lordship, amount is 1 crore. Lordship may appoint any advocate or
Mr. Name of Justice J.P. Das was being suggested in one of the cases.
Yes.
So,
my lord.
J.P. Das.
My lord. My name.
Item 26.
My lord, so filing the rejoinder affidavit, my lord.
Where is the arbitration? Why? Are you raising objection?
No, well, it's formal counter affidavit.
Why are they?
My lord.
What is this amount?
My lord, agreement clause is at page 81
Yes.
of the petition, my lord. Clause 14, dispute settlement.
What is the disputed amount?
My lord, disputed amount is 4 crore 1 lakh 68,229 rupees.
Yes, any name?
My lord, senior advocate DP Nanda may be appointed.
Yes.
Yes, very well.
Item 27.
Obligation.
My lord, I am appearing for Paradip Port Trust. We have filed Bhaklotnama, but our name has not been indicated in the list.
Yes.
And for the petitioner, petition for appointment.
Our name hasn't been indicated in the list.
What is your name?
Saroj Kumar Pehura,
Saroj Kumar. When did you join?
2018.
2018. Then what is the difficulty with your topmost button of your shirt?
Sorry, sir.
Broken.
Studio broken.
As requested on behalf of Mr. So and so, learned counsel states that he has instructions to appear on behalf of the opposite party.
Paradip
So,
Trust.
he shall be filing his wakalatnama when?
Yesterday. Yesterday we have filed.
You have filed?
Yes.
That he has filed wakalatnama on behalf of the opposite party on 10/9/2024. So, what do you want?
We need some time.
Seeks adjournment to file reply. You will file reply.
Sir.
To file a response to present application seeking appointment of arbitrator. As requested, discuss matter on 2 weeks.
Published.
Specialist.
Okay, please. Your Lordship.
Item number 1.
Lordship, this is the second journey of the petitioner. Earlier, your Lordship.
Anticipatory bail application.
Yes, Your Lordship.
Second.
Yes, Your Lordship.
Not maintainable.
Your Lordship, earlier no document was filed whether the accused is involved in this case or not. That's why Your Lordship rejected this application. Now I have filed one the report of the investigating officer that the petitioner is behind the conspiracy. Is amongst the conspiracy. In support of that, I have filed, Your Lordship, kindly see page 12.
So the situation is that you have got yourself involved in the criminal case for maintaining your anticipatory bail application.
I am the owner of the vehicle.
Owner of the vehicle, so what?
I am not present. Your Lordship, hold that.
All right.
I have
all
not
right,
named
all
in the
right,
FIR.
Let me see the police report.
Yes, Your Lordship. Your Lordship, can you see page 12? The paragraph, the first paragraph. On this above, the above noted case was registered and investigated into. During further investigation, I visited the spot, examined the complainant and other witness and recorded the statement under section 161
All right.
CRPC.
So I am going to ask you to file an affidavit.
Yes.
Stating the source from where you procured this.
Right. Your Lordship, the forwarding report. This is the forwarding report.
Yes.
This is the forwarding report in respect to co-accused person who was arrested and forwarded to the court. And this document was very much available with him when he filed the first application for anticipatory bail. Now he is saying that because no documents are available, now we also can look at the date of the forwarding, 17/2/2024. And FIR has been registered. We'll also look at on 16/2. At the first instance, he filed the anticipatory bail and said that there was no document to show that petitioner is alleged accused. Now he is relying on a document which was very much available at the time of filing of the first application for anticipatory bail.
I was not the conducting counsel at that time.
Then you should not have accepted this.
Your Lordship, one more thing, Your Lordship, may I suggest, Your Lordship. The vehicle has been released. Now my release order issued in my favor. But apprehending arrest, reasonably I am apprehending arrest. The IO will arrest me because he has mentioned that I am behind the conspiracy.
So you may not be arrested because of section 41A.
They are not giving me say, on the section 41.
They may give you notice.
Yes.
How do you know? The petitioner had earlier approached this court seeking grant of anticipatory bail, which was rejected by, where is that order?
Your Lordship, page 18, Annex 4.
Rejected by an order dated 3/5/2024 on the basis that he had neither been named in the first information report, nor there was any material to suggest that during the course of investigation, his name had surfaced. First of, the petitioner has renewed his prayer for grant of anticipatory bail by making this application, this time with bringing on record a forwarding report dated 17/2/2024 of the ASI of Jankia PS, whereby other accused persons, how many were forwarded upon their arrest in connection with the concerned criminal case. So where is the conspiracy? Where is the conspiracy?
In the page 12, further it is clearly evident that the owner, driver and transporter combined organized the crime and stolen the cattle from Jamusai and transported
With
to
reference to the contents of the forwarding report, learned counsel for the petitioner has submitted that the petitioner has apprehension of his arrest because he is being considered as one of the conspirators. Stop. Next. The case has been registered for the offence punishable under sections 379, 411/34 of the IPC and section 11 bracketed A bracketed D bracketed E of the Prevention of Cruelty to Animals Act 1960. What is the punishment in 11A-D, Prevention of Cruelty to Animals Act?
2 years.
Stop. Next. I am not inclined to entertain the present anticipatory bail application in view of the fact that the petitioner has not been able to make out a case that after dismissal of the petitioner's anticipatory bail application earlier, the police ever attempted to arrest him.
He's a man of other state. He's a man of other state. So the police could not arrest him, not just to arrest him, but his vehicle could not be released in spite of the 457 release order of the vehicle.
So the apprehension of arrest does not appear to be justified. Front counsel appearing on behalf of the petitioner has further submitted that the petitioner is a resident of
Andhra Pradesh, I think.
Your Lordship, Telangana.
Telangana. So, next. Be that as it may, I am not inclined to entertain. When was the FIR registered?
16/2/2024.
I'm not inclined to entertain the present anticipatory bail application. Stop. The petitioner shall be at liberty to surrender before the court below within 2 months from today. That observation was there.
No, the lawyer simply said that it's not maintainable because it is not made.
Today, if according to him, You have not been charge sheeted, nothing. Why are you?
My vehicle I could not release my vehicle. Although the order has been passed in my favor to release the vehicle, the petitioner apprehending to approach the IO.
Failing to approach the IO.
IO held me guilty in this case. I am a conspirator
Very
according to
difficult.
the IO.
Mr. Counsel, what kind of submission? These submissions are made by the litigants, not by a lawyer.
Your Lordship, IO held me guilty.
IO has nothing, has done nothing.
And
IO is just investigation. Cannot hold you guilty. Court can hold you guilty.
IO taking me in the forwarding report, he mentioned that.
The petitioners shall be at liberty to approach. You can say, go and say that.
Your Lordship granted all other co-execution granted by this honorable court. Annexure 5 series.
That's right.
In the similar circumstances also.
Yes. It has been submitted that the other co-accused persons have been granted anticipatory.
Yes.
Anticipatory bail.
Yes, Your Lordship. Your Lordship granted.
Anticipatory bail. So then why are you worried? Then you can be granted regular bail if you are arrested. What is this? Unnecessary.
Item number 2.
Yes.
Lordship, I have to approach the court below?
No, you may not.
Lordship, may I observe that the parity may be maintained? I will surrender before the court.
I will not say anything.
Lordship,
Don't
otherwise,
spoil your case.
Your Lordship, how could I release my vehicle? That is the.
That I'll have to sit after my retirement. If I sit in my chambers, then only I can advise.
I am helpless, Your Lordship. I'm undone. If I go approach at the IO, he may arrest me.
And if you go to the court, then
court may or may not release me.
Why? Others have been granted anticipatory bail.
Their court bills are not considered, Your Lordship. They will simply say the High Court not consider. How could we consider?
All right.
In
I
all the
cannot
cases
enter into argument with you. It's very difficult for me to. All right. Yes.
Item 2.
We are permitted to withdraw, my lord.
Item number 3.
3 petitions are before Lordship, my lord. Serial number 3, 4, and 5. All are arising out of same case. 2 are my lord ladies.
What have you done?
But the case is that
NDPS.
NDPS, my lord.
I can remember the case from your face.
Yes.
That your lordship was called for the case diary. Whether yes, the case is my lord. Now I'm consenting for 2 ladies, my lord. Prosecution case is that in the police, my lord, while investigating in another theft case, they got a reliable information that somebody is carrying contraband ganja in the bus. So bus, my lord, is full of
yes, I remember the facts also.
When they entered into the bus, they found a person is sleeping in this sleeper seat, and in his seat, my lord, contraband articles were there. Thereafter, my lord, he disclosed that 2 other ladies, they are sitting in other seats, my lord. Their personal search was there, nothing was. And my lord, it is the prosecution case, admitted, my lord, from their personal search, nothing was found. He disclosed the name of these 2 persons, 2 ladies, my lord. Police went and found the contraband ganja from his seat. That, my lord, accused is, my lord, serial number, my lord, Barun Banerjee is from Barun Banerjee, BLAPL number 1368. From his seat, my lord, contraband ganja was 4 bags were found containing contraband. These ladies, my lord, 2, they are sitting in seat number 19 and 20. No, my lord, nothing was
submitted.
Charge sheet submitted.
Charge sheet submitted, and Loki Banerjee, the wife of Barun Banerjee, main accused me. Not that they are known to each other.
And Ram Sakhi Devi is no another lady. Another accused, Ram Sakhi Devi is another accused, my lord. Ram Sakhi Devi is bail application number 5386.
See, once your application is rejected.
No, not rejected, my lord. Not rejected.
Today it can be rejected.
Your lordship,
Therefore,
your lordship, my lord.
Some time.
No, by that time, my lord, so far, your lordship, I withdrew the application. So far, the Ram Sakhi Devi is concerned, but the investigation is going on. Your lordship directed me to you. If charge sheet has been submitted, then you move charge sheet because the investigation is going. How can I ascertain at this stage? So now my lord, charge
Now
sheet has been
that,
submitted.
the first question put by lordship was section 37.
No, 37,
What he
how,
has to get over
what is
lord?
37, how, my lord, my submission before lordship, how much 37 will come into play with me, my lord, so far these two ladies, neither is found, nothing is found from their possession.
Last date, on the last date also, we had read section 37.
Yes,
If
my
I
lord.
remember correctly.
Yes, my lord, I have read, I also,
It is up to you. You
I had also, my lord, submitted before lordship.
All right, you argue, we will decide.
And my lord, so far the case, except the confession of the co-accused.
Yes. When you are in custody.
My lord, I am in custody since 28/11/2023.
Yes.
8/11/23. Except the confession of the co-accused, no other material.
Yes.
So far, these two ladies is concerned, my lord.
All right.
And your lordship, your lordship has to this honorable court has also considering the co-accused confession, has considered.
In this case.
Not in case, but other courts.
That is not the law.
Pardon?
That is not the law which has been laid down. Had the law been laid down by this court, I would have followed that.
A law led,
But that in one case, someone has been granted with.
No, not law led. It's a reported judgment of this co-bench, my lord. That co-accused confession. Not I am giving the co-accused confession. My lord, in so many cases, my lord, considering co-accused confession, my lord, this honorable court is considering only basis of the confession of the co-accused. No other material is available against me.
It is not a judgment.
So many judgment. I can so my letters. So
judgment.
Again, yeah, I'll show you a lot similar judgment.
Only the risk which you run is that you may find a judgment from this court. You can do that.
I will give you a judgment of this honorable court also, except the confession of the co-accused.
All right.
No other material.
Yes. When do you want?
1 week time, next week, next Friday, your lordship.
As requested on behalf of the petitioner to support his submission based on the court's decision that an accused is entitled to bail for an offense punishable under the provisions of the NDPS Act, which is covered under section 37 thereof. In case the implication is based on confessional statement of a co-accused. Yes. Is this matter on? Yes. 2 weeks. Yes.
Item note 4 and 5.
3, 4, 5. Arising out of 3 application, my lord. This 3 passenger, my lord. 2s are ladies, my lord.
For orders item 6.
Item 6, my lord. This matter from first time in the list.
This has come for the first time in the list after 19 years.
First time in list, my lord.
So what was your relief?
My lord.
What is this case about?
My lord, conviction under sections 500 and 501B and 502B of IPC and sentence period is 1 year, my lord. It should be kindly taken up 1 week after, my lord. They come first time in the list.
Right. What is the conviction, a sentence?
The sentence is 1 year simple imprisonment.
Hmm?
1 year simple imprisonment. Defamation case, my lord.
And have you spent some time in the study?
Probably defamation.
Huh?
Probably.
Please hold your breath. Please sit.
He may not have done any.
If defamation.
Please sit for a second. Huh?
739 of 2003.
397.
395 of 2005.
397, 2005.
Please sit, Mr. Counsel. You are not well. 397.
I seek for adjournment, my lord. I want to take instruction wherever the petitioner, my lord. Also keep it to. First time it
I
has gone.
requested on behalf of the petitioner to seek instructions about his whereabouts. Since the matter has remained pending for more than 19 years. What is this matter on? Next week.
A week after, but Baleswar, we have to send letter, register letter.
No register letter.
10 days
You
time, we
inquire.
receive at least 10
No,
days
no,
time.
nothing.
Item number 7.
There is no representation on behalf of the and the GA. It's present for the state. Stop. On 26/7/2024 also there was no representation on behalf of the petitioner. Stop. This application is accordingly dismissed for default. The bail bond purchased by the petitioner, if any, pursuant to this court's order dated 29/8/2001 stands cancelled. First off, the interim order dated 29/8/2001 stands vacated. Stop. Next, the petitioner shall, however, be at liberty to make an application for restoration of the present application. Yes.
Item number 8.
Same minutes listed on 26/7.
Same, huh?
Earlier listed on 26/7, same matter minutes. None appeared on 26/7.
Same one.
Item number 9.
9 and 10, both were listed on the same 0.67 my lords.
Same order.
Item 10,
10 also same.
item 11,
Well, sir, unfortunately, my name appears for the petitioner. my lords. May I pray, my lords, I will ask one of my friend. My friend is there, well, he will do this.
My lord, item 11, the brief has been transferred since 2010, my lord. Our name may be little late, my lord.
11.
11, my lords.
11.
So what is the offense?
I know.
I don't have the file.
376.
My friend says brief has been taken up back by the petitioner since long, my lords.
Since 2010.
Friend counsel. Mr. So-and-so states that the petitioner had taken back the brief from him nearly 10 years ago, and there is no instruction thereafter. Stop. This application is accordingly dismissed. Any entry, the thing? For non-prosecution. The bail bond furnished pursuant to this court's order dated 6/11/2001. If any, comma stands cancelled. Stop. The petitioners have, however, be at liberty to apply for restoration of this application. Why was this referred to Lok Adalat? Where is the question of Lok Adalat? All right, yes.
item 12,
So, order dated 14/1/2000, interim order dated 14/1/2022 stands like. Liberty.
item number 13, item 14,
Please, one. The petitioner convicted under section 341, 323, 452, and 41,
41.
323,
Yes.
452, and 376.
What is the sentence?
For 341,
376.
SI 376 for 7 years.
Yes, the courts are here.
Yes, sir.
Yes, yes.
Well, here the offense is of the year 1991. Thereafter, the learned trial court have convicted the petitioner under all the sections, and the bare reading of the judgment, my lord, there is no eyewitness to the occurrence of which is alleged by the informant, who is the PW1, the victim. There is
So whether the victim was examined or not.
Yes.
She supported.
She supported the
Then
case.
why
Only she supported the case, no other.
How can you say that there is no eyewitness?
My lord,
She is the eyewitness.
as per her statement, there are two other persons present at the spot: her son and her husband's another wife.
All right.
Well, PW 2 and 3.
All right. Where is her deposition? Oh, the court paper was. The deposition is in English.
Yes.
Scan. Scan. It's not the scan. Scan. Scan.
Yeah.
How many witnesses were there?
6.
6.
Yes.
And who other than PW1?
PW2 and PW3.
They have also supported.
No, they have not supported the 376 part, my lord. They said that they were present at the spot, but when the accused dragged the PW1 to the field, they left the spot. Thereafter, they left the spot. My lord, they were present there, but they left the spot. And my lord, PW6, the IO, were at paragraph 8. He said that the victim in the FIR did not stated about the rape, my lord. But while examination under 161, she stated that it has happened. But in paragraph 8, while examination before the London trial court, the IO deposed that the victim has stated that the said fact that out of anger she had complained about rape in exaggeration manner.
Where?
My lord, in PW6, paragraph 8.
And are you on bail?
Yes, ma'am.
Since?
2003. Look, I'm in custody almost for 3 years after conviction, my lord, during trial and conviction.
But your sentence cannot be reduced in any case. Either you can be acquitted or
So far, the 376 part is concerned, my lord, it is, my lord, from the deposition witness of the depositions witnesses, my lord, it is clearly saying that it is a created one, that for the any anger to satisfy their grudge, they have made out a means a statement, my lord. So it is her son and her husband's second wife who were present at the spot. They didn't say anything. She also
No, but
didn't.
because she was raped in the house of the accused.
No, man, not in the house. While they are going to the police station, it is stated that the accused maid there and dragged her to a field.
No, but her son is PW3.
But son is saying that it is contradicting from the PW1 and PW3. The son PW3 is saying that she is dragged from the house of that person name.
No, this impression I am gathering because
Look, PW3 first page, second para towards last, my lord. When we reach the house of Dhiran Mahanta, accused reached there. From the house of Dhiran Mahanta, accused dragged my mother by holding her hairs. My lord, whereas PW1 stated,
PW1 is the victim.
Victim. While we were going on a nearby field, the accused again met us. By that time, my son and my husband's other wife Jala were with me. Accused caught hold of my hairs and dragged me. My lord, the son is saying the accused dragged from the house of Dhiren Mahanta, while the PW1 is saying that the victim herself saying that while they are going to field, the accused dragged her.
All right, just give a synopsis of the evidence of the witnesses.
My lord, I'll give you 3 days time.
Pardon and counsel appearing on behalf of the petitioner. This was the estate.
No, sir. May I
Or
say,
it ask someone else to appear.
Mr. Arnav Behra, who was allotted with me, my lord, his name may be recorded. Mr. Arnav Behra.
This matter on next week. Please come prepared. That. Otherwise, I'll have to do the entire exercise.
Well, I will notes, my lord, short note.
Just summarize.
Item 15.
The state applicant, which is criminal revision application, is pending since 2003. So there is no representation on behalf of the petitioner. So this application is dismissed.
Item 16.
Conviction is under 307 IPC. Sentence of 7 years with 15,000 rupees fine. Now, it's going through the judgments, my lords. Considering the injuries, the medical treatment was only for 11 days, my lords. And the discrepancy between the 2 doctors is evident, my lords. If your lordship will give me some time, I'll prepare a chart.
Do it. That will help me
My lords.
deciding the case. And what is the age? What was the age of the petitioner? Have you?
Petition. Then was 22 years, my lords.
Or, yes, next week.
No, a week after.
All right, 2 weeks.
Item 17.
17, may I please, Your Lordship? I'm on behalf of Mr. D. Naik. Your Lordship, it's a very old matter and we don't have the whereabouts of the petitioner.
Discuss matter on 2 weeks. So as to enable and counsel for the petitioner to inquire about the whereabouts of the petitioner. Is this application is nearly 21 years old. Yes, prevention of food adulteration. What is the sentence? All right, 2 weeks.
Grateful, Your Lordship.
Item 18.
for representation on behalf of petitioner. This is matter on next week.